Good morning, all. This case management conference is in the matter of CFI 079-2023 and is being held by way of video conference before Justice Rene Lemiere, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimants are represented by White and Case. Lead counsel is Mr. Tom Montague Smith, KC, and Mr. Ravi Jackson. The defendants are represented by Habib al-Mullah, and lead counsel is Mr. Stephen Docherty. Thank you, Your Honour.
All right, thank you. Before we go any further, I am going to ask Mr. Doherty to confirm which defendants you appear for.
Yes, Your Honour, I'm appearing this morning and making submissions for D1 and D3. So that's Mr. Shehata and Health Insights. So it's the third defendant's jurisdiction application, and then later it's Mr. Shehata's set-aside stay application.
Yes, so you do not today appear for the second defendant?
No, and we set out that position in our defence. So the defence's advance for the first defendant and the counterclaim.
All right, thank you. All right, well, I don't know if you've discussed how you want to go about this. I think I indicated earlier that we would hear the jurisdiction argument first. If that is suitable to counsel, we'll proceed that way and ask Mr. Doherty for you to start.
Yes, thank you. Subject to anything Mr. Montague Smith has to say, I'd assume that was the basis in which we'd kick off. Just before I start, a brief bit of admin. Your Honour will have noticed that when I put my skeleton argument in, I didn't provide page references. On the basis of that point in time, I didn't have access to a paginated bundle. Unfortunately, I still didn't until yesterday afternoon, so I haven't been able to provide that updated version. And for whatever reason, I gather there's some issues with the new system. I can see that most of the authorities that I've referred to haven't made their way into the electronic bundle. And so it's probably not an ideal position for Your Honour to be in. Subject to your view.
I am struggling with aspects of it, Mr. Doherty, but we will do our best today.
Yes. Well, what I propose to do, because I won't be able to take you to some of the authorities to read the extracts that I'm going to refer to, is I'll read them, and after the hearing, what I can do is put together a brief schedule of the references so that you have them in writing and the paragraph numbers that I referred to, and perhaps we can just cut through it in that way. On jurisdiction, there's quite a bit to get through. Zoomed out, I'll deal with it by looking at two broader issues. One part of it is procedural, and the other deals with the substantive test that the court applies on jurisdiction. We say that both end up in the same place, which is the court doesn't have jurisdiction, or at the very least it shouldn't exercise jurisdiction in respect of the claims against the third defendant, albeit you get there through a slightly different route each time. And I'll address it in that order. So I'll deal with the procedural issues that arise in relation to the jurisdiction application first. To give the outline, the claimant's position at this hearing is that the jurisdiction challenge is out of time and you can't consider it. And in any event, its position on the court's substantive jurisdiction appears to be that Joinder has in fact taken place. And so that ship has sailed when it comes to any argument undoing that decision. And that's based on the court's Nest investments jurisdiction, which I'll go through in a bit of detail later. For a variety of reasons, we say that's incorrect. And in fact, the procedural position we're in explains one of the reasons why the court doesn't have jurisdiction over these claims against the third defendant at all. And I'll go through the detail of it, but essentially there are 5 points on procedure which I'll go through. The first, in answer to the asserted procedural bar, we say that the court made express orders with respect to the filing of acknowledgement of service by the third defendant and its jurisdiction challenge, and those were complied with. Second, we say that there is a significant and highly material procedural irregularity affecting the way that the claimants have gone about seeking joinder in this case, as well as the way they've gone about amending their case. And the effect of that, we say, when you work through it, is that the claimants fall to be treated as having both amended their particulars of claim and joining the third defendant prior to service. And that seems to be how they've gone about things from a procedural perspective, given that neither application was made in the proper way. But the important point, probably one of the most important points in this jurisdiction challenge, is that the effect of all of that is that the third defendant can't be considered as joined under the necessary and proper party jurisdiction at all, because the Nest Investments jurisdiction isn't engaged. The third point...
I'm just trying to understand what you're saying, Mr. Doherty. You're not saying that the third defendant hasn't been joined. You're saying that simply, aren't you going back to the court doesn't have jurisdiction in respect of the third defendant? I mean, the court has joined, an order has been made joining the third defendant. There's been no appeal against that order. I'm not quite sure where you're going procedurally.
Procedurally, the position is, if you're, and I'll work through the nuts and bolts of this, but if you're a claimant, you can bring your claim all at once against all of the relevant parties when you issue a claim form. If you've issued your claim form but you haven't served it, you can also join those parties without seeking the permission of the court and without having to raise it by way of a contested application under RDC 20.7. And we say that the proper analysis is that's what happened in this case. And the problem that gives the claimants is that if you want to rely on a jurisdictional hook, which is the court's necessary and proper parties jurisdiction, that is, the court exercising its discretion under Rule 20.7 to join a party, you have to have made that application and have the court exercised its discretion in that way after the claim form has already been served.
But that's what happened. That is what happened, isn't it? The claim form was served on the first and second defendants, and at the hearing, on whatever date it was that I don't remember, Mr. Montague Smith made an oral motion to join the third defendant, and the third defendant was joined on the basis that it was a proper party, or I forget whatever the precise words are in the rule, a necessary and proper party or a necessary and desirable party to be joined. So all of that happened. You might say there was some irregularity in getting to that point, but then you would have to appeal against that decision if you wanted to attack it on that basis, wouldn't you? It's now happened, and it's really, I'm having difficulty with understanding a submission which perhaps I wrongly understand to be saying it shouldn't have happened.
No, Your Honour, the question is how it happened. If you want to invoke the Nest Investments jurisdiction, you have to make an application to join a party pursuant to Rule 20.7. And I'll take you through what happened at the March hearing, together with what the rules say should happen. But the long and short of it, from the defendant's perspective, is there has never been an application under Rule 20.7. The Rule 20.7 wasn't mentioned at the March hearing. The words desirable, I don't think, were mentioned once at the March hearing. And so one has to work out.
You might need to go through this, because my current understanding is that's the basis on which I joined the third defendant. Again, it often happens that neither counsel nor the courts spell out in detail the rules and criteria, but I might be wrong, but my recollection impression is that's the basis upon which the defendant was joined. I don't know what other basis it could have been joined on.
Yes, I will take your honour through that and explain how we see the case. In effect, it boils down to.
And let me take it a stage further again. Supposing that that's wrong. Supposing neither counsel nor the court turned their mind to it and just joined the third defendant without giving any thought to the source of jurisdiction. Having been joined, and if there is jurisdiction by reason of Rule 20.7, isn't that it? Really, whether there was some irregularity in getting to it is not to the point, is it? Unless you appeal against that order.
No, Your Honour, because there's a number of. Well, let me put it this way. When we go to the decision in Nest, what the court says is that when the court is considering applying Rule 20.7, it is being asked to consider desirability of joinder by reference to a number of factors, which include questions of jurisdiction and so on. But ultimately, the important point is that the court is being asked to exercise a discretion, having heard all of the competing factors for and against, as to whether or not it's going to join a party. And it's the fact that the court's exercising that discretion, that role of policing jurisdiction, that meant that there was sufficient justification to read into the rule of court a basis on which to enliven the court's jurisdiction, because not all, not every single provision of the RDC is sufficient to enliven the court's jurisdiction, and that's certainly the position post Sandra Holding. There has to be some intention behind the rule to get you through Article 5A 1E, its jurisdictional gateway. And the problem here is that when the court considered the issue, as I'll come to, what Your Honour was told is this is an application that can be made ex parte, which is wrong. And Your Honour was not referred to the proper test for joinder at all, and so didn't consider the exercise of the court's discretion in that way. And of course, it didn't hear from the third defendant. And indeed, for reasons I'll take you to, the position at the hearing was that you had concluded that you couldn't be satisfied that service had taken place, and so you made orders for the claim form to be served on all parties electronically after the hearing. And so where that puts the parties is in the position of the claimants, in effect, having joined without notice and without permission of the court, as is perfectly entitled to do, the third defendant, but prior to service of the claim form. Where that gets you is that the Nest Investments jurisdiction is pretty clear in saying that in order to utilize that jurisdictional hook, there has to actually be an application for joinder under Rule 20.7. It's not enough to say that, well, the party is already joined, and if we wanted to, we could have joined them under Rule 20.7. That argument was tried and was unsuccessful, both at first instance and an appeal in Nest, and I'll take you to that extract. And I'm always happy to provide a plug, but the second edition of the Blue Book deals with this section and says that the procedural position is...
I didn't know there was a second edition, Mr. Doherty. Is that hot off the presses?
It is hot off the press.
Hot off the presses, Mr. Montague-Smith. All right.
I'm sure that Mr. Montague-Smith will be happy to provide a substantial discount to the right buyer.
Well, I'm going to be in Dubai next week, so I'm sure I'll find a copy there.
Hopefully, I've managed to crib a page for you, but the consensus view expressed there is that although that is the procedural position of the court, if that's going to change, it's going to take a change of the RDC or JAL or the court law. And so we say that it may well be that the claimants could have made their application under Rule 20.7, but they didn't, and they're stuck with the consequence of that. There's a fair amount to build through to show you that that's the answer. But we say that once you go through that, it's pretty clear that that is, in fact, the answer. And that's probably what I'll spend a considerable amount of time this morning dealing with.
If you're right, Mr. Doherty, does that mean what I should do would be to do what? To set aside the order joining the third defendant and then await another application from the claimant to join them under 20.7, and then we do the whole thing again. Is that?
No, and I don't think that that's how the rule works. What would happen in those circumstances is Your Honour would make an order dismissing the claim on the basis that the court doesn't have jurisdiction, and that's the end of it. The jurisdictional gateway isn't available.
But as I understand it, the basis you're putting is a procedural one only. It would seem odd to me, but you may well persuade me, for the court to say it doesn't have jurisdiction where the basis for it is that the wrong procedure was followed, and that if the proper procedure had been followed, it would have jurisdiction. In those circumstances, it intuitively strikes me as odd that the court would dismiss it on the grounds of lack of jurisdiction.
Well, 2 points to that. I think the first is that is the way it is. I'm afraid that's what the rules currently say, and subject to a rule change or legislative change, that's the position. But in any event, what we say is that even if Your Honour was to go on and consider what the substantive test might have been, for those reasons, you shouldn't accept jurisdiction anyway. That's why I said at the outset there are two ways to go through this. One is procedural and one is substantive, but they do both get you to the same answer, and both points are as important as one another.
I'm sorry, you're probably used to me interrupting you, Mr. Doherty, but if you're right on both procedure and substance, then it doesn't really matter. But it's if you're right on procedure but wrong on substance, that's where we get to what strikes me as an odd position.
Well, I suppose what I would say is that if I'm right on procedure and wrong on substance, the appropriate form of the court's order is to dismiss the claim, and the claimants can then appeal, which they'd have to, because what you would effectively be asking the court to do is to overrule the position in Nest Investments that the Court of Appeal had supported.
But wouldn't, if I dismissed the, what would I be dismissing? The claim?
The claim against their defendant.
On the basis that it had been improperly joined?
On the basis that the court doesn't have jurisdiction. So the way you would imagine the position is to say, let's pretend that there had never even been an application for joinder, that the claimant had just named all of the parties at the point of issue. And the third defendant was to come along and say, well, you don't have jurisdiction because the court, none of the JAL gateways are satisfied. At that point in time, faced with that application, Your Honour would say, well, what are the JAL gateways? You'd go through them. You'd say, well, is this a DIFC establishment? No. Is this a contract or a tort, which is a connection with the DIFC? No. Is this an appeal from a regulatory body? No. Is there a rule or a law which says that the court has jurisdiction? No. And then you go to 5A2. Is there a jurisdiction agreement? No. In which case you would dismiss the claim as for want of jurisdiction. So that's what we say the proper analysis is once you get to the end of this.
And perhaps suppose your easy answer is it doesn't yet arise, but if that happened, does that preclude the claimant then making another application to join the third defendant?
Yes, because we would say that the question of the court's jurisdiction has already been decided. It would be an abusive process to seek to arrive at the court's jurisdiction in that way again, or it would be an abusive process otherwise.
That's where it strikes me as intuitively odd that where the court would have jurisdiction if one procedure is followed, it doesn't have jurisdiction if another procedure is followed. It seems to be a triumph form over substance.
It may be, but both the view expressed in both the first and second editions of the Blue Book is that you need a change of the law to change that position, and it's a procedural oddity. But then there's a perfectly credible argument that the jurisdictional gateway through 20.7 is itself a procedural oddity compared with.
Did you, Mr. Doherty, did you promise me a copy of the page in the new edition of the Blue Book that says that?
Yes, that is in the that one is actually in the bundle.
Oh, is it?
Yeah, page 1865.
All right.
We're getting a lot of plugging in this morning.
Yes, I'm having a little difficulty with the bundle, so I might rely on what you tell me.
I will go through that point. I promise you in sufficient detail. The third point on procedure is, even putting all of that aside, the court has a power under Rule 20.8, which says that it's entitled at any time effectively to unjoin a party because it's undesirable for them to be part of the claim, which gives the court, in any event, a discretion to take a considered approach to the question of desirability, as though it had been considering an application under 20.7 for the first time. The fourth and fifth points are to deal very briefly with what's suggested as our submission to jurisdiction of the DIFC, because we say there is no submission jurisdiction in the DIFC, and also the assertion that we've acquiesced in respect of the arguments we raise on the arbitration agreement, and to explain why, as a matter of procedure, we say that's not right.
Okay.
And then I'll take you on to the substantive points we make on the application of, if we pretend this was an application under 20.7, what are the relevant factors and so on. The first point I promised you is, when it comes to the procedural bar, the third defendant has acted in accordance with the court's direction. And the starting point for that, Your Honour, is the order that you made back on the 12th of July, page 741 of the bundle. And there you said, paragraph 1 is the claimant shall file and serve the Part 7 claim form particulars of claim by the 26th of June. The third defendant shall file an acknowledgement of service by 10th of July, and the third defendant shall file, if any, pursuant to Part 12, its jurisdiction challenge. And so we say that the really straightforward point here is that the orders were dealing with the filing rather than the refiling of the third defendant's acknowledgement of service, as well as setting out an express order fixing the deadline for receipt of a jurisdiction challenge. Those deadlines were complied with, and to that extent, the asserted procedural bar by the claimants is not really a genuine issue. And in fact, the court had already considered, and we say dismissed, the arguments that the claimants still appear to be making at this hearing. And that, of course, was when Your Honour fixed those directions, the parties had written to the court and put correspondence on the court file. And on the 10th of July, the claimants put an email before the court because they hadn't agreed to the inclusion of paragraphs 2 and 3 of the order that we've just looked at, dealing with filing the acknowledgement of service and the jurisdiction challenge. And the basis for that is they say that the third defendant needed to file their acknowledgement of service 14 days after the 18th of March, and that their failure to file an acknowledgement of service was raised on the 14th of April hearing. And in your order of the 15th of May, you made provision for the filing and service of pleadings, but no provision for filing an acknowledgement of service. And they said that accordingly, pursuant to Part 12.4 RDC, it's out of time. And so the 12th of July order reflects the fact that those arguments have already been considered and rejected. And so Your Honour should proceed to hear this challenge in full in the normal way. And there's a backup position to that already, and I'll deal with it quite briefly because I don't know how much time I need to trouble Your Honour with all of this. But if one actually takes a proper reading of the court's rules, this idea that it has to be served within 14 days of the claim form being served is not strictly correct. What Part 12 says is this. 12.2 says the defendant who wishes to make an application must first file an acknowledgement of service. 12.3 says the defendant who files an acknowledgement of service does not by doing so lose any right that he may have to dispute the court's jurisdiction. And then it says an application under this part must be made within 14 days after filing an acknowledgement of service and supported by evidence. So what the rules say is an application must be made within 14 days after filing the acknowledgement. It doesn't say that you have to file that challenge within 14 days of service of the claim form. The relevant trigger point is the date that you in fact file your acknowledgement of service. So it's irrelevant whether it's considered late or not. There are, of course, other potential consequences that can arise under the RDC if you're late with your acknowledgement of service. For example, you might subject yourself to an application for default judgment, but that's not an application that the claimants decided to make in this case. And so even under the rules, filing your acknowledgement of service late, even though we say that isn't really what happened here, it doesn't rob you of your right to challenge jurisdiction, provided that you do then file your acknowledgement and that you make your challenge within the relevant time frame. So either analysis, Your Honour, gets you to the point that you should proceed on the basis that the jurisdiction challenge has been properly made at the proper time. The bigger point I said I'd then come to, Your Honour, is my second point, which is the consequences of the...
Just on that, Mr. Dougherty, your application was made within 14 days of the acknowledgement of service, was it?
Yeah, so we made it in accordance with the court's directions on 12th of July. So that was a file acknowledgement of service on the 10th. And then the jurisdiction challenge was by 24th.
Okay. Yes, thank you.
So the second point has to do with the consequences of this procedural irregularity. As I said, there's a bit of working through to go through here, but it is an important point, and it probably merits going through it in enough detail. The starting point for this is that the proper process set out in the court's rules is that if you're a claimant and it's pre-service, so you've issued your claim form but you haven't served it, you're at liberty more or less to make whatever changes you want, either to the case in the claim form or to the parties. And the relevant rules which deal with that are Rule 18.1, which says that a party may amend his statement of case at any time before it has been served on another party. And RDC 20.11, which considers a similar point in respect of joinder, which says that the court's permission is required to remove, add, or substitute a party unless the claim form has not been served. And then 18.3, which straddles both amendment and joinder, but it says if a statement of case has been served, an application to amend it by removing, adding, or substituting a party must be made in accordance with Part 20. So the flip side of that, of course, is that if the statement of case hasn't been served, you don't need to make a Part 20 application in that way. If, on the other hand, you've already served your claim form and you want to either amend the substance of your case or the parties, you have to make an application on notice explaining the basis for your amended case or explaining a basis for joinder. And the relevant rules that deal with that are, first of all, we've just looked at 18.3, saying you have to make an application in accordance with Part 20. Rule 18.2, which says if a statement of case, which includes a claim form, has been served, a party may amend it only, 1, with the written consent of all other parties, or 2, with the permission of the court. So if you haven't got consent, you need permission. 18.14 says, when making an application to amend a statement of case, the applicant should file with the court the application notice, the copy of the statement of case with the proposed amendments, and the evidence. And then RDC 20.4 and 20.5 in relation to Joinder say that the application to add or substitute a new party should be supported by evidence setting out the proposed party's new interest in or connection with the claim, and that the application notice should be filed in accordance with Rule 23.2, and unless the application is made under Rule 20.9, I'm going to come back to that, it has to be served in accordance with Rule 23.25. So, in other words, if you're going to take either step, joinder or amendment, unless you're going to do it pre-service, you have to make a Part 23 application. If you do that, you've got to make it on notice, and you have to go before the court and explain to it why you're making that application. And it's, of course, at that point that the court will consider the relevant threshold test, which would be the application of Rule 20.7. Is it desirable or necessary and proper to add the party? And that process obviously makes sense, because even if one thinks about the structure of a claim form, when you file your claim, you have to fill in boxes which explains what's your claim about, what the remedy you're seeking is. And also there's a box which says what's the basis upon which you say the court has jurisdiction to hear the claim. And so if a claimant went about its case in the proper way, and let's say just named all of its parties at the outset, then a party who had no connection to the DIFC can look at the claim form, it can look at the asserted basis of jurisdiction, and if appropriate, it can then issue a jurisdiction challenge with its acknowledgement of service and bring a jurisdiction challenge in the normal way. On the flip side, clearly, if you've already served your claim form on who are then the parties, you can't just change it or add a party without giving them notice of the application. Because one can just consider, I don't know, a scenario where a party to be joined has no material connection to the DIFC, and that party surely is entitled to come before the court and say, well, no, we challenge the amendment or we challenge the proposed joinder because we dispute the court's jurisdiction to hear that claim or to hear a claim against that party, and therefore they shouldn't be joined. And the problem that arises if you don't allow a party to make those submissions and the court can just join them on an ex parte basis is that a claimant could pretty easily seek to abuse that process in such a way that the party who's on the receiving end of the joinder order or on the receiving end of an amendment effectively can't challenge the court's jurisdiction or even make submissions about it. Because in the claimant's analysis of the case, the court's power to order joinder in and of itself is what confers jurisdiction on the court under Rule 20.7. So by the time you're joined, without making even a single submission, there's already nothing you can do about it because the court's jurisdiction is enlivened. And on that analysis, if it's right, there's nothing you can do about it as a party who's been joined, having had no say whatsoever. And that simply can't be right, because if that is correct, it would effectively give the court an unlimited international jurisdiction, which is totally incapable of being properly policed by, amongst other things, hearing proper argument and submission. We say it'd be ripe for abuse by parties who are seeking to use anchor defendants effectively to avoid bringing their claims in the proper forum. And more or less the same point applies when you're dealing with an amendment. So if an amendment is pre-service, it's fine because a defendant can look at the case that's pleaded and the asserted jurisdictional basis, and by reference to what's pleaded in the details of claim and the remedy sought, challenge jurisdiction if it's appropriate to do so. If you make the amendment post-service and without notice, it robs a party of the ability to challenge the amendment on the basis that there's no prospects, amongst other things, because the court doesn't have jurisdiction. And so, for example, it would be open to a party going through that process to say, file and serve a claim form originally which pleads a cause of action asserting that there is a DIFC contract. So Article 5A 1B is engaged. And and let's say it's a contract between two non-DIFC entities. If you assume at that point that no jurisdictional challenge was made within 14 days of service of that claim form, on the claimant's analysis of how it's gone about things in this case, it could then simply just seek to amend what falls within the four corners of its claim without permission to plead a load of ancillary issues which have nothing to do with a contract negotiated or agreed within the DIFC. It may even remove the assertion of there being a DIFC contract, but having done so, and the time having already passed for making a jurisdiction challenge, it would say, well, you can't challenge jurisdiction now because it's too late. The claim form was served way back when, and you didn't challenge jurisdiction then. And again, we say that analysis obviously can't be right. That's why parties can't go about proceedings in this way.
Could not the defendant apply to strike out the amendments to the particulars of claim on the grounds it's introducing claims which are not within jurisdiction?
Well, not if the claimants are right about this case, because what they say is that if you haven't made your jurisdiction challenge within 14 days of filing the acknowledgement of service, yes, that means either you've submitted to jurisdiction already and there's nothing you can do about it, or there's a procedural bar which prevents you from raising that argument subsequently. So it is a material difference challenging the case on it.
If they're wrong on that point, and you can raise the jurisdiction claim, would it be open? Well, sorry, I'll start that again. Is it not the case that you could apply, a defendant could apply to strike out a pleading raising as the grounds that there's no jurisdiction in relation to that particular claim? Not that the party should be dismissed in the sense the claim, the assertion would not be the court has no jurisdiction over the party, but the assertion would be the jurisdiction is limited to the basis on which it was joined and doesn't go any further. Or is that not open?
Well, I'm not sure that would be open, because the argument, if you get yourself into the framework of this case as analysed by the claimants, they would say it doesn't matter what the narrower basis of the court accepting joinder in the first place is, because once the court has accepted joinder, its jurisdiction effectively becomes unlimited by the fact that the jurisdictional hook is JAL 5A 1E. And so it doesn't matter what the framework or the expansiveness of the claim is, because the jurisdictional hook is just on the basis of the application of Rule 20.7.
Yes.
And it's also putting it the wrong way around. This is why when you make these sorts of changes in litigation, you have to put in an application and you have to demonstrate to the court why it's proper for that order to be made, rather than the order just being made and then a defendant having to come, because precisely these sorts of problems arise. And it's not, this isn't just moaning about procedure. The court hears enough moaning about procedure from counsel. The procedural defects here go far beyond a hypothetical problem, because as I've said, the claimant's position is D3 is already joined, ergo the court has jurisdiction, nothing you can do about it. And third defendant's jurisdiction is out of time because you had to have filed that challenge, I think they say by the 2nd of April, despite the fact that without seeking permission from the court, they've then gone and filed a claim form and particulars of claim almost 3 months later on 26th of June of this year, which included a whole series of brand new claims seeking relief that wasn't set out in the Part 8 claim form in the first place. And the claimant's position is, well, that's all fine, and they can do all that without the court even hearing from the third defendant on the question of jurisdiction. And, you know, with the greatest respect, we say that's an absurd position to put to the court that it's hamstrung on jurisdiction as a consequence of the claimant's own efforts to circumvent proper court procedure. The rules are very clear about what the claimants needed to do, both with respect to joinder and to amending its claim form and particulars. And so if it had considered it was making these applications post-service of the claim form, which is the position it advances today, both applications needed to be Part 23 applications. So for amendment, as I say, it's RDC 18.14, which we've already looked at. But the general provisions set out in Part 23 also spell out what's supposed to happen. So Rule 23.2 says the general rule is that an applicant must file an application notice. And then the notice provisions in Part 23 say, so this is 23.4 and 23.5, the general rule is that a copy of the application notice must be served by the applicant on each respondent, even if such service is on short notice. And 23.5 is that an application may be made without serving a copy of the application notice, if permitted by a rule or a court order. But there's no court order here permitting the applications to proceed without notice, nor is there any relevant rule saying that you can proceed without notice. And I'm going to come back to that point in a moment when we go to look at the transcript of the March hearing. And beyond that, what Part 23 says, 23.69, is that there are narrow exceptions to when courts can deal with applications without a hearing. This case doesn't fall into any of those exceptions, so the applications should have been heard by the court, and none of that happened. I said I'd come back to there not being a rule saying that the court can make the order without notice. And this brings me to the point, which is that back in the hearing in March, which of course Mr. Shehata attended in person without legal representatives, the claimants proceeded on an incorrect basis. And what they said was that they were entitled to make an application to join a party ex parte. And the reference to the relevant part of the transcript, Your Honour, is at page 520. If Your Honour could just let me know when you have that,
Yes,
I
have that.
Perfect, thank you. So in the middle of the page, it's the third bit of speaking, Mr. Montague-Smith, and he takes Your Honour to the rules he wants to refer to. He says, we have 20.11. I'm afraid I wrote most of these, so if there are problems with them, you can blame me. But it's 20.11. It was a long time ago. It says, the court's permission is required to remove, add, or substitute a party. And then we go down, and he says, and then paragraph 20.13.1. I can make the application without notice in the ordinary way. That must be right. And 2, it needs to be supported by evidence setting out the proposed party's interest in or connection with the claim. I would say that you have that in the witness evidence. And then you say, I'm satisfied about that, yes. I'm grateful, this is over the page. So that's all I really need to show you.
Mm-hmm.
The rules that were referred to were the wrong basis. I mean, just to make a couple of points about the exchange that takes place there, Your Honour wasn't referred at all to Rule 20.7 or what the relevant test under Rule 20.7 is. The word desirable doesn't appear in the transcript of the hearing so far as I can see. And so there's no reference to the 20.7 test, even implicitly. And instead you're referred to 20.11 and 20.13. 20.11 we've looked at, that just says that the permission is required unless the claim form hasn't been served, which of course it actually hadn't here. We'll come back to that point. And then 20.13 says, an application for an order under Rule 20.9, brackets, substitution of a new party where existing party's interest or liability has passed, close brackets, may be waived without notice and must be supported by evidence. Now, that rule is irrelevant because this was never a 20.9 edition or substitution, which deals with liability passing from one party to another. So the rule is completely irrelevant. And the amendment position is slightly less important for jurisdictional reasons, but I'll run Your Honour through what the procedural position is on that anyway. But again, it's clear an application was needed if you're going to introduce new claims that weren't on the original claim form. You can't just proceed on the basis that there is some implied permission from the court to make those amendments. And in fact, when Your Honour entered judgment on the declaration issue in this case back in May, you explained quite expressly that the permission to file particulars of claim in this case was permission to file particulars in respect of what was already then in issue in the Part 8 previously. And so reference to that and to your judgment is page 611 of the bundle. Which is the end of your judgment, where you set out directions for how the case should proceed for the element which moved to Part 7. And in paragraphs 168 and 169, you say, I agree those are appropriate directions with two changes. First, the claimant should first file particulars of claim in respect of their set-aside claim. Second, the defendant should, if they like to do so, file any counterclaim, and the court will make the following directions. Then you say, by 29 May, claimant shall file particulars of claim in respect of their claim that the agreement dated 19th of December 2021 between the second defendant and the third defendant be set aside, and the first defendant account to the second defendant for the profits resulting from the agreement. So what was expressly envisaged at that point in time, Your Honour, is that what was going to be pleaded was the specific set-aside claim for the 19th of December 2021 agreement. And you also expressly define that part of the claim at paragraph 2 of the order which you made. That's at 582. It's within the same document, it's just at the top end, which says the claimants claim that the agreement dated 19th of December 2021 between the second defendant and third defendant be set aside, and the first defendant accounts to the second defendant for the profits resulting, brackets, the quote set aside claim. So on the scope of what's actually pleaded, there's never been permission to add to that, one, a claim for an injunction, two, the claims which have now been put into the claimant's particulars about the agreements being void for absence of authority, and three, either of the claims relating to the purchase order. And it's our position that you can't just ignore what's an obvious problem here. So first, the court can't just assume in retrospect that it's proceeded on the basis that it ordered, for example, Joinder and permitted an amendment on the court's own initiative. The reason you can't do that, Your Honour, is because the rules are clear that if the court is going to make an order on its own initiative, those still need to take a particular form. And the relevant rules are 4.10 through to 4.13. But in short, those say if the court's going to make an order of its own initiative, you have to give the other party an opportunity to make representations. If the court makes an order, it must give each likely party 3 days' notice of a hearing. And it says that the court can make an order without hearing from the parties, but if it does so, there's a prescribed form of judgment that needs to be given, which is that the party affected by the order may apply to set aside. But importantly, the order must contain a statement of the right to make such an application. And so that wasn't the basis on which any of the orders were made by Your Honour in this case. Neither the March order nor the May orders gave liberty to apply to set aside, as we can't proceed on that basis. But in any event, I've cited, and I'll put this in a schedule at the end, the case of Gulf Wings and A&K Trading, which is a Court of Appeal judgment I've referred to in my skeleton. And there are a couple of paragraphs there which I'll read to Your Honour, but as I say, I'll give them to you in writing subsequently because they're not in the bundle. But first of all, paragraph 18 of the Court of Appeal's judgment there says, it's a fundamental legal principle, with certain well-recognised exceptions, that a party is entitled to be informed of an application against it and given an opportunity to respond to such an application and to make representations on it before an order is made. There's a sentence which says this application applies as much to contempt as to any other type of application. And then it says the general rule is an applicant must file an application notice unless the court dispenses with that requirement. A copy of the application notice must be served by the applicant on each respondent, even if it's short notice. The permission of the court is required for an application to be made without serving an application notice, and such permission will only be granted in exceptional circumstances. Then paragraph 19 refers to, this is the final sentence of paragraph 19, there being exceptions, and that there are provisions for informal notification, but the essential point remains, namely that except in exceptional cases where for very good reason an application notice is not required, an application must be made by notice and notice must be served on the other parties to proceedings. And in any event, if for whatever reason the formalities cannot be observed, the substance of the application must be notified to the other parties, who must be given a proper opportunity to be heard. And again, paragraphs 20 and 21, I would read them out, but they refer to the need for there to be something exceptional. And again, this wasn't an exceptional case, and the court wasn't asked to proceed on the basis that this was exceptional. It was told that this is what the rules say, which was incorrect. A second point is that the court can't just assume that because under mistaken premises that an order for joinder was made, that alone is sufficient to give rise to jurisdiction, as the claimants assert. And it's on that point, Your Honour, that one needs to go back to the fact that the asserted basis of jurisdiction here is exclusively Nest Investments and Rule 20.7. Nothing else has been asserted. And if one actually looks at the detail of the judgment, we say it's clear that the court was proceeding on the basis that it needs to exercise its power in a way that polices the desirability of joining a party. And that includes considering questions as to whether or not the DIFC court is an appropriate jurisdiction. The Nest judgment is in the bundle. It starts at page 1776. And the first part, I think for ease, it's probably easier to do it now, is to take Your Honour to, I'm just waiting for mine to load.
Yes, I've got two laptops trying to do it and neither of them are loading it at the moment.
I think you might need a supercomputer.
Yes.
First of all, it's paragraphs 17 and 18. So when you get there, it's the bottom of page 1780 and 1781. And if Your Honour can just let me know when you have that, I'd be very grateful.
Afraid I'm making no progress at all with this, Mr. Doherty, on either laptop.
Or shall I read it and hopefully it will spring?
I think it might be quicker in the end.
So paragraph 17 and 18 deal with this point about procedure and the fact that you have to actually make and exercise the court's jurisdiction under 20.7, and it's not enough to join the party in a procedurally different way, for example, prior to service. So this is a commentary on what was decided below. I think it was Justice Giles below. It says, paragraph 17, additionally, is recorded by the judge. The claimants submitted that there was jurisdiction because Mr. El Fadl was a necessary and proper party to the claim against DTME. That was put as grounds for present jurisdiction over a defendant included in the original claim form. But, as the judge remarked, when it was unpacked, it was something different. The contention was that the court could order under Rule 20.7 that Mr. El Fadl be added as a new party in the circumstances there set out. That rule provides under the heading addition and substitution of parties that, and then it sets out the rule, so the court may order a person to be added if, one, it is desirable to add a new party so that the court can resolve all the matters in dispute, or two, there is an issue involving the new party and an existing party which is connected to the matters in dispute in the proceedings and is desirable to add the new party so that the court can resolve that issue. And then paragraph 18 says, the judge held that reliance upon the rule at that time was misplaced, as ultimately was accepted by the claimants. The possibility of an order under the rule did not mean that jurisdiction existed at the time, in circumstances where Mr. El Fadl had already been named as an original party to proceedings when issued and served as such, followed by his challenge to jurisdiction. On its own terms, the rule is only applicable to a situation where a new party is to be added to the existing proceedings, in existing proceedings, and the relevant test set out in subparagraphs 1 or 2 is met, whereupon the court is given a discretion whether or not to add the party in question. So it's really the final sentence there, which is the most important one. The rule is only applicable if the new party is being added and the relevant tests set out in the subparagraphs to 20.7, 1 or 2 are made out. And at that point, the court has a discretion whether or not to add the party to the proceedings. And as I said earlier,
in this case, it was adding a party to the proceedings, wasn't it? The first and second defendant were existing parties, and then the third defendant was added as a party.
yes, but you have to be added through the gateway of the exercise of the power. That's really the point, because having looked at the rules I've already taken you to, let's say, for example, even in the Ness case, Mr. El Fadl wasn't an original party in the claim form, but the claim form hadn't yet been served. What the parties could have still done there was added them. They could have added them without the permission of the court, and without having to give notice to the party they were adding, because the rules say that you can do that prior to service. And if you do it in that way, you are not going through Rule 20.7, and the court is never considering the exercise of its discretion under Rule 20.7. And so they would then find themselves in precisely the same position as Mr. El Fadl in Nest, where by the time the court considers the question of desirability, they have been joined, they are already a party, but they are not a party as a consequence of the exercise of the rule. And that means that the jurisdictional gateway can never actually be engaged. And we say that the judgment in Nest, when you look at the detail of it, is clear in setting out the importance of the application and the proper application of the test, because the rule itself is pretty broad. Is it desirable to join a party? It's still subject to the court exercising its discretion in the proper way. And the court, of course, has to police its jurisdiction in a way that means that it's not going to become exorbitant, or that it can have jurisdiction over any claim, regardless of how tenuous the connection is. And if one looks at, I don't know if you've got Nest up, but I'll read you the extract. It's still...
I've got it now.
Thank you. So paragraph 47, as we continue down there, the repeated refrain from the court is you have to adjudicate on when the test is met. So paragraph 47, page 1785, in the middle of the page, says when RDC 20.7 provides that the court may order a person to be added as a party in the circumstances there set out, the question is whether that is properly read as giving the court a power to assume jurisdiction over a party where the criteria of that rule is met, regardless of the JAL 5A1A to D gateways. And the rule doesn't expressly confer jurisdiction by using that term, but it clearly sets out a criterion for the joinder of a party in the same way as RDC 21 does. So the point to emphasize there are the words when the criteria of the rule is met. And in this case, there was no argument or engagement in that issue. As I said, the word desirable wasn't uttered at the March hearing. And Your Honour was referred instead to different criteria at Rule 20.13, which was about an ex parte application, which just needs to set out a party's interest or connection with the dispute, but with no discretionary rule of the court to police that. And this point comes up again and again in the Nest judgment. So, for example, if one looks at paragraph 48, there's the basis on which the court is saying that this can't just be intended to be a procedural rule. And one can debate whether or not Nest is right about that, given the CPR has precisely the same rule, which doesn't play that jurisdictional role in precisely the same way. Be that as it may, because the court is exercising a discretion which can give it jurisdiction, there are a number of factors that one needs to weigh up, and that includes 48.3, so 1786, top of the page. It says that the court can weigh up issues of forum conveniens and any other matters which militate for or against joinder and make a decision which facilitates justice being done in the most appropriate manner, where there's some common issues. So again, it's telling us that if you're making an application through 20.7 and you're trying to establish one of the court's gateways, the court has to actually carry out an evaluative exercise, weighing up factors militating for and against, and that includes questions of jurisdiction. And then at paragraph 52 on this same page, the same point comes up again. It says the indisputable fact is that the wording of Rule 20.7 is wide enough to confer jurisdiction upon the court by giving it the power to make an order in question if the criteria are satisfied. The words give the court the discretionary power to allow joinder in the circumstances outlined. So yes, the court can join in that way, but if it's going to order joinder, which confers jurisdiction, the court has to exercise that discretionary power in the light of all of the relevant circumstances, and importantly, in light of recognition of the correct test to apply. And for that reason, we say that Nest can't confer jurisdiction in this court. And the quandary arises because of what happened back in the March hearing and the basis on which the court was proceeding. And we say that when you get into questions of there are some irregularities here, how do we chart a course through it? For reasons I've already taken your honour to, you can't just say, well, the court could make these orders in its own initiative, and so I'll just proceed on that basis. That would be an improper basis on which to proceed. But there is a much more straightforward route. If I can take you to page 514, back to the transcript of the March hearing.
Yes, I do have it.
And Your Honour will recall that the outcome of that, and I'll take you to the order, is you adjourned the hearing. And one of the reasons was that your finding at the hearing was that service hadn't taken place. So at the bottom of the page, you say the statement that the process server visited the location and due to the apartment being locked at the time of notice delivery, is on the face of it consistent with Mr. Shehata, the first defendant's statement to the court that he was absent from the house and it was locked up, there may be an explanation of how it was that the documents were served, which is consistent with the statement that the process server visited the location and found the apartment locked up. However, in the absence of such information, I'm not able to make a finding that the documents were served on Mr. Shehata, and indeed, on the basis of the material currently before me, I do not make that finding. And if Your Honour scrolls down to the top of page 516,
Yes.
he said, all of that leaves me in the position that I'm not able to find in the face of Mr. Shehata's statements to the court that he did not receive the documents personally served on him, and he did not receive the documents in the post. I am unable to go away from those statements. And from those findings of fact, the statement of affairs and where procedural the sort of procedural matters had reached is reflected in the order that you made at page 539. Paragraph 1 refers to the adjournment. Paragraph 2 says Health Insights is joined as the third defendant. But then paragraph 3 says the claimants may serve the claim form on each of the defendants' nominated email addresses. And if one takes a snapshot at that particular point in time, service hasn't been affected, but there is an order for alternative service made by email. And by the time that that service is affected, D3 is already joined as a party to proceedings. In other words, the appropriate way to look at this is as though the court has allowed that joinder to take place pursuant to Rule 20.11, which is the court's permission is required, and that would be on notice application to remove, add, or substitute a party unless the claim form has not been served. So on this analysis, it's correct, no application was needed. And so service of an application notice wasn't required, and the court's permission wasn't required, and the court didn't have to hear detailed argument about the question of joinder or the test under Rule 20.7, because at that point in time, the claimants were at liberty to add whoever they wanted. And that certainly appears to be how the claimants in effect proceeded, in saying, we can make the application without notice, that must be right, and why it never actually sought to persuade the court or lay out submissions as to why an order should be made under Rule 20.7. And we would say that a similar approach can be adopted on Amendment 2. It's slightly less important on Amendment, but your 12th of July order said the claimant shall file and serve the Part 7 claim form and particulars of claim by the 26th of June. One can work through that in a way where we say there were party proceedings, the actual party bit of the party proceedings were resolved. And what was to continue proceeded by way of Part 7 claim form and particulars, and that one could find logic and justification in treating those documents as though they had not been served yet at that point in time. And the sort of logic of that approach is because, 2 points really. One, the court has a broad discretion to give directions it sees fit whenever it's received an objection on the use of the party procedure. That's derived from Rule 8.18. And what the court's rules also say in an analogous context. So let's say if you've commenced a claim in the Small Claims Tribunal and the court moves the claim to the Court of First Instance, the position is that in the Court of First Instance, you as a claimant are at liberty to file and serve your claim form and proceed on the basis that you're making a fresh claim. And that means that you're entitled to amend prior to service as you see fit, as though you're just starting proceedings in the Court of First Instance for the first time. And there's authority for that. There's a case called First Middle East Distribution and Orange Chameleon. And if you were to adopt a similar logic to this case, you can say the claimants made their amendments prior to service, which they would have been entitled to do in much the same way as you could join a party prior to service. If I'm wrong about that, then the claimant's amendments haven't been validly introduced at all, and they need to make a Part 23 application, and it would be open to D3 to contest that. But we say that the analysis that I've set out is the most reasonable way for the court to work through the procedural irregularities in this case. And of course, the most important part of that is that the procedural history means that it is a matter of fact. Joinder occurred pre-service. That's a fact. And joinder occurred without any application being made under Rule 20.7. That's also a fact. And that is highly material because the operation of Nest Investments is expressly premised on the court exercising a discretionary function in determining whether or not, amongst other things, it should assume jurisdiction. Having already been joined by the claimants pre-service and based on the wrong provisions of the RDC, we say the claimants can't now just rewrite history or seek to belatedly make an application under Rule 20.7 because, like in Nest Investments with Mr. El Fadl, the third defendant is already a party.
So we're back to where I was a while ago. I would have to remove the third defendant as a party, and perhaps a variation on what I was putting to earlier. You drew my attention to Rule 20.24. If I was to remove the third defendant under that rule on the grounds that it had been improperly joined, rather than on the basis of no jurisdiction, that would then leave it open to the claimant to seek to subsequently join it again, wouldn't it?
No. And the reason for that is the appropriate form of order the court can make when faced with these circumstances is you make the declaration that the court has no jurisdiction to hear and determine the claim.
Well, that's what I'm putting to you, Mr. Doty, whether that is the appropriate order or whether the appropriate order would be, or determination would be, if I otherwise followed your arguments, that the third defendant was not properly joined, and I make an order for their removal on the grounds that they weren't properly joined. If I was, now of course, as I said, if I was with you on both procedure and substance, in effect, the question doesn't arise. But if I was to find in your favour on your procedural arguments, but then find as a matter of substance there is jurisdiction, as I have difficulty with understanding how, if I made a finding as a matter of substance there was jurisdiction, I would dismiss the case on the basis of no jurisdiction if what I had actually found was that the third defendant had been improperly joined because the proper procedure hadn't been followed. And so what I want to know, I know you say no, it should be on the grounds of no jurisdiction, but why is that so rather than exercising a power under 20.24?
The reason, well, the primary reason for that is because the appropriate course here is to follow Court of Appeal authority in Nest. And what happened in Nest is the court faced with the question, which is the question before the court, does the court have jurisdiction? The answer is no. And when the court comes to that answer, the appropriate order to make is that the court hasn't got jurisdiction over the third defendant. Having made that order, we would say that if the claimant was to go off and make another application for joinder under Rule 20.7, we'd make 2 points to say, well, it's one, it's res judicata. 2, it's an abusive process to seek to reintroduce jurisdiction in that way. You had the opportunity, you didn't take it. And 3, if the court were to proceed on that basis, it would be in effect a departure from the position laid out in Nest Investments, which is Court of Appeal authority, and it would be an appealable point, which can be adjudicated by the Court of Appeal.
What was the order that the Court of Appeal made in Nest Investments?
So I can take, well, the order in first instance, first of all, is the court declared that there's no jurisdiction to hear and determine the claim against the second defendant. If you forgive my waiting for the wheel to turn.
The order was that there was jurisdiction. There's nothing in Nest which indicates that there wasn't jurisdiction, if that's the submission, or indeed that the fact of the procedure about in the way in which the issue arose led to there being no jurisdiction. It's not what Nest says at all.
We obviously don't. Well, I've taken you to paragraph 17 and 18 of Nest,
which recite the first instance decision, although that wasn't pointed out in the submissions.
Respectfully, I did say that this was discussing the judgment below of Giles. In fact, the paragraph itself says that.
Where in Nest Investments do I find the outcome of the case?
Yeah, so it's at 1777, so it's appeal allowed. The point of principle was not overturned in paragraph 17 and 18. I cited it earlier, Your Honour. I don't know if you read it. The relevant section from the Blue Books 1865.
No, I haven't got to that yet. Let me read that. 1865, is it?
Yeah.
Yes.
Which again you will see refers to paragraph 17 and 18. The first instance decision.
Yes. Yes, all right.
So the point really is that the claimants now are in precisely the position that Justice Charles is dealing with in Nest, which is the way this has come about is that the third defendant is a party prior to being served, and it's misconceived then for the claimants to rely on Rule 20.7 is enlivening the court's jurisdiction because it doesn't apply. And the views expressed are, that procedural position might be unduly technical or onerous, but that is the way it is. And until the RDC changes or the court law changes or JAL changes, that is the way it is. And we say that's a real problem for the claimants. Still, no application has ever been made through the proper gateway, which means that Nest simply doesn't apply. And if it doesn't apply, there's no other basis for jurisdiction under the judicial authority law. And as a matter of procedure alone, we say the application by the third defendant succeeds. And that is as far as Your Honour needs to go. Obviously, I'm going to deal with the other points in any event.
Yes. Yes.
As I said, the secondary position is if Your Honour is going to go on to consider the substantive part of it, which I've got the indication, of course, that you're probably going to deal in detail with both of these points. But Rule 20,
my usual approach, Mr. Doherty.
I have been on the receiving end of a number of your judgments, and they're quite considerable in their detail. So I understand that. The secondary analysis, you still can't go down the route the claimants are asking for, which is, just ignore all of this and simply decide that the court necessarily has jurisdiction because Joinder has taken place. If Your Honour was of the view that the order for Joinder is made, and Your Honour took the view that that's already sufficient to confer jurisdiction, the simple point is that the court then possesses the discretion to undo that order, and that's Rule 20.8. So the court may order any person to cease to be a party if it's not desirable. So if the court can grant jurisdiction pursuant to 20.7, in the same way the court can take it away on the grounds that it's desirable. And there's not really a question of there being some kind of Henderson abuse here, because the arguments haven't been heard before, and the court is effectively exercising its discretion properly for the first time if it goes through that route. So that's another way of pointing out why the procedural bars the claimants assert don't really exist. And if I can deal very briefly with the final two procedural bars that are asserted against me before going on to that bit of substance. The first is the assertion that D3 has submitted to jurisdiction. I won't go through the detail of it, but the court, at least until Sandra Holdings is overturned, the court has to actually be satisfied that it has prima facie jurisdiction. You can't simply submit to the jurisdiction of the court in the way that's been asserted. And I won't take you to Sandra Holding, but the relevant paragraph's the one that everyone's read a million times, at paragraph 76. And the similar point relates to the procedural bar that's said to apply when it comes specifically to the argument about there being an arbitration agreement, which is that Article 13 says that if an action is brought before the court in a matter which is the subject of an arbitration agreement, if a party requests not later than when submitting its first statement of the substance of the dispute, dismiss or stay. And what's said is, well, Mr. Shehata put in a witness statement, and so he can't come and challenge jurisdiction now. Obviously, I've already made the point, Your Honour, about the application on jurisdiction being made in accordance with express court directions. But ordinarily, if one was to read what is meant by a statement on the substance of a dispute, normally the first statement on the substance of a dispute from a party is its defence. In this case, there is no defence because the jurisdiction challenge has been made, in which case the first statement on the substance of the dispute is the jurisdiction challenge itself. The express language used in Article 13 clearly draws some distinction between a statement on substance and a statement on procedure. So when the claimants rely on Mr. Shehata's first witness statement, that was expressly a statement made in support of an application contesting the use of the party at procedure. There are 2 points to that. One is Mr. Shehata was perfectly clear in that statement, because he said, I make this statement pursuant to directions issued by the court, that the defendants file and serve evidence regarding the use of the party at procedure. And two, the scope of the court's order permitting that statement to be made said, the judge has directed that any written evidence in support of the defendant's argument on the claimant's use of the party at procedure be filed by the 12th of April. So on its face, those statements were about the procedure that had been adopted by the court. It wasn't a statement on the substance of the dispute for the purposes of Article 13. And in any event, the material put before the court, in fact, prior to that, I think the skeleton came first, did assert the arguments that are now relied on. So the skeleton made reference to the validity, the arguments about the validity of the assignment agreement, and that those had to be determined in arbitration. And it also said the court will need to determine jurisdictional issues in respect of the third defendant, and it invited the court to make directions in relation to that, which is ultimately what happened. So the claimants can hardly come today saying that they are surprised or taken aback by the third defendant's application. It's been telegraphed all along. And I think that's all I propose to say about that, which draws a line under the procedural points. And I'll come to what we have to say about the substance. And just to give a broad overview, the position the third defendant takes is that the basis on which the DIFC court draws jurisdiction in any aspect of this case is actually extremely narrow to begin with. So it's simply an agreement between the members of a non-DIFC company, so that's the articles, to submit disputes as between members arising from the articles to the DIFC court. I think it's been previously accepted in evidence by the claimants that the DIFC court isn't even the default court of competent jurisdiction for Dubai clusters companies. But based on the articles, the claimants seek to use the first defendant as an anchor to ask it to go on to resolve other contractual disputes where none of the parties are DIFC companies, none of the parties even do business in the DIFC, none of the individuals concerned are based in the DIFC, and where there's no real discernible link to the DIFC. And that's even where, as we'll see, those parties have already agreed that their disputes covering that subject matter should be resolved by arbitration. And so to hear the claims against the third defendant, we do say that the court would need to assume this exorbitant jurisdiction, ignoring the fact that the court's jurisdictional gateways aren't engaged for reasons I've given, but which further ignores express jurisdiction clauses, established rules of law about who can or can't bring claims, which should properly be seen as in the gift of a company. And I'll work through that by taking you to essentially 3 points after I take you to the pleaded case, just to show you what it is. But the first is the JAL gateways aren't satisfied. There's no proper basis for the claim against D3. Second, even if they were satisfied, the court operates under a duty to stay or dismiss the proceedings as a consequence of the existence of an arbitration agreement, or at least part of the proceedings which are governed by the arbitration agreement. And third, whilst our primary cases, you don't need to go into this, but if Your Honour was to run through a discretionary exercise in relation to, and I'll deal with them together, the desirability of joinder or forum non-conveniens, the factors weigh strongly against proceeding with the claim against D3. So we seek the dismissal of the claims. As I said, I'd start just by taking you to some of the pleaded case, because I don't think that some of the issues now raised were before you when you looked at this case back in April. The particulars of claim setting out the amended claim starts at page 17 of the bundle.
Yes, I have that.
And there are a few components I'll refer you to. So if we start with paragraph 13, first of all, which is bottom of page 19, top of page 20.
Yes.
Which are assertions about the ownership and the vesting of rights of Medica Client Care, MCC. And the asserted case is that at all material times prior to the 19th of December 2021, the second defendant owned the IP rights in MCC. That invites, we would say, a number of questions, not least how it said those rights were acquired. But on the claimant's own case, and I think in its claim form, their suggestion, I think, is that that question falls to be resolved by onshore UAE law, or at least that's what's cited as being the substantive law governing the dispute in the claim form. The defendants dispute that aspect of the case. And the first defendant...
Can I just backtrack for a minute today? Why are we going through this? Is these submissions directed to the point that there is an arbitration agreement between the second and third defendants, and the proceedings, that part of the proceedings which is subject to the arbitration agreement, shouldn't continue? Is it something to that effect?
That's one part of it. So there are claims under two contracts. One has an arbitration agreement.
To do that, wouldn't you have to bring an application to stay the proceedings or part of the proceedings under section Article 13 of the arbitration law?
That's what one of the components of this application is.
Oh, is that expressly a part of the application, is it?
Yes.
Oh, I'm sorry. I should have picked that up.
I should be clear that that aspect of the case relates to the assignment agreement, which is the
yes,
the 19th of December 2021, and then we also rely on the further positions we advance on jurisdiction as it relates to that agreement as well. So we make all the same points about desirability and form non-conveniens in any event.
Yes.
But we also make those points which cover both the, well, I'll call it the assignment agreement and the purchase order, which is the one that's been subsequently introduced. Yes. And so the reason I'm taking you to some bits of the pleadings is one of the questions that Your Honour will consider is what the natural forum is. And so some consideration of the pleaded issues is relevant to that. And I just wanted to show you how it was set out.
Yes, please do that. I'm not familiar with those new pleadings.
Thank you. As I was saying, the D2's position is at least prior to 2020, December 21. D2 owned the MCC rights. It doesn't put any positive case about how those rights were said to have been acquired. The first defendant disputes that. So what the first defendant says is he was the author of MCC and he assigned certain rights to the third defendant in Malaysia. So on either analysis, we're talking about, at least as far as positive assertions go, IP that was authored by an Egyptian national and resident and owned by a Malaysian company. And so in either case, we're not talking about an issue which concerns DIFC intellectual property law. And when it comes to then the two contracts and the basis on which they should be void or voidable or set aside, I'll deal first with the assignment agreement because that's the agreement that Your Honour's looked at previously. And you can see it's set out at paragraphs 29 through to 35, starting at page 23. So this is, first of all, what Your Honour referred to as the set-aside claim.
Right.
So this is what was originally included in the party claim form, and which you've heard some oral argument about. So it said in paragraph 29 that the assignment agreement falls to be avoided under Article 79.6 of the DCC regulations because the first defendant was interested in the transaction and that those interests conflicted with the second defendant. First defendant was aware, and as a consequence of the failure to declare his interest, he's in breach of Regulation 79. And then para 34 says, in breach of Regulation 79 of the regulations and thereby in breach of the terms of the articles, first defendant failed to disclose his interest. In the circumstances, we apply for an order setting aside or an order directing, well, and an order directing an account.
Yes.
So in essence, it's a contractual claim between the claimants and the first defendant, where the relevant contract is the articles. The claimants say that the articles have a jurisdiction clause in favour of the DIFC court, and that they incorporate the DCC regulations. And so a breach of the regulations is a breach of the articles, entitling them to then sue under the agreement. So that's the old case. There are then parts of the case which are completely new. One is a claim for an injunction. That's against D1. So I don't mean to go through that now. It's not really relevant at this stage. But if one looks, first of all, at what's alleged in respect of the set-aside agreement, the assignment agreement, if we go up to paragraph 27, there's a new component which seeks to invalidate the agreement, which is not based on the operation of the regulations, but says that the agreement was void. One, because the first defendant had no actual authority on behalf of the second defendant, and two, because there was no ostensible authority. That wasn't a feature of the Part 8 claim. Breaking it down, essentially, the pleaded case becomes there's a contract between two companies, the second and third defendant, and when that contract was executing it, the person who purported to do so didn't have actual or ostensible authority, and therefore it's void or voidable. And both of those aspects of the pleading are then mirrored, so they're set out in almost identical terms in relation to another agreement, which wasn't part of the Part 8 claim form. So it's a paragraph 16 through to 23. And it sets out the same points again. So we've got an application to set aside under the articles due to conflict, and then the same point made about authority again. As I say, there are 3 points we make. The first one is blissfully quite short, which is that the judicial authority law isn't engaged. So where we get to, if Your Honour is with me in what I've said before, is we don't have jurisdiction under Article 5A1E. And beyond that, you just need to tick through them. No DIFC entities, no pleaded facts about DIFC contracts or acts or omissions, not an appeal from a DIFC body, and no opt-in to the jurisdiction of the DIFC courts under 5A2. And so when you run through the JAL, there's no gateway that the third defendant claims can come through, and on that basis, the court doesn't have jurisdiction. The second point is also fairly straightforward, but I'll take a little bit more time on it. That applies even if the analysis I've already given you is wrong. But in short, where there's an arbitration agreement in relation to the subject matter of a dispute, the court is under a mandatory obligation to stay. So even if Your Honour was to take a view that there was some benefit to linking or joining proceedings, you can't do it as a matter of discretion. And I think Your Honour probably will be familiar with the legislative framework on this, because I think you looked at it fairly recently in the Gulf Petrochem case. But I just have a couple of points to make about the proper construction of Article 13. So it says, if an action is brought before the DIFC court in a matter which is the subject of an arbitration agreement, the DIFC court shall, if a party so requests, not later than when submitting the first statement and substance, dismiss or stay such action unless it finds that the arbitration agreement is null, void, inoperative, or incapable of being performed. So really there are 3 limbs to that. First, is there an arbitration agreement? I'll show you it, but here I think the answer is plainly yes. Second, is the agreement null or inoperative? And I don't understand there to be any allegation to the effect that the arbitration agreement itself, as distinct from the assignment agreement as a whole, is void in this case, or that it's incapable of operation. At which point, what the court is left to consider is whether the dispute before the DIFC courts is in a matter which is the subject of an arbitration agreement. If I can take you to the agreement itself, that's page 880 of the bundle. If you're on, can let me know when you have that, but hopefully it should land with clause 6.2 of the assignment agreement.
Nothing at the moment. I have nothing, but I'll let you know when it comes.
Certainly. Mine's just loaded up. Hopefully that means yours will follow. So clause 6.2 says, this is the December 21 agreement. With respect to any dispute arising out of the formation, performance, interpretation, nullification, termination, or invalidation of this agreement, or arising therefrom or related thereto in any manner whatsoever, shall be finally settled by arbitration in accordance with the provisions set forth in the DIAC arbitration rules by one or more arbitrators appointed in accordance with the rules. Our position is...
I just want you to go back a minute. You passed over the point whether the agreement is null or inoperative, with the comment effectively, well, as you understand it, it's not claimed that it is. But the agreement in which the arbitration agreement is found, that agreement the claimant asserts to be invalid, doesn't it?
It says the agreement it asserts the agreement is invalid, but of course there's a question over who gets to adjudicate that issue. And so the actual arbitration agreement itself, in that respect, is severable from the substance of the contract and its invalidity. And in any event, the DIFC...
Well, it might be severable, but where it's part of an agreement, whereas I've understood it, it said the agreement is invalid because it was made without authority. Well, that would apply equally to the arbitration agreement, wouldn't it? I mean, we know the principle of separability and so on, that there could be reasons why the arbitration agreement might survive, notwithstanding that the agreement in which it is found is defective in some way. But for the moment, I can see the argument that if the whole agreement is made without authority, that includes the arbitration agreement, doesn't it?
No, I suppose two reasons for that. One is purely practical, which is if you could avoid an arbitration agreement by merely asserting that the agreement itself was void, parties could routinely not seek to litigate before courts issues which are probably within the jurisdiction.
Not merely by asserting it, and I take your point, the question then might come, who decides, the tribunal or the court?
Yeah.
That may well be.
Yeah, sorry, Your Honour. Speaking of the second point is that the arbitration law, the DIFC's arbitration law, tells us that the arbitral tribunal is competent to rule on those questions of its own jurisdiction. So Article 23 of the arbitration law says that the arbitral tribunal may rule in its own jurisdiction, including any objections with respect to the existence or validity of the arbitration agreement.
Yes.
For that purpose, the arbitration clause, which forms part of the contract, shall be treated as an agreement independent of the other terms of the contract. A decision by an arbitral tribunal that the contract is null and void shall not by itself determine the invalidity of the arbitration clause. Yes. So if there is an issue like that, I don't understand one to have been at least explicitly asserted, but even if it was an issue, it's an issue in any event for a tribunal, not for the court. So I guess that gives teeth to the practical point I made, which is that a party can't just circumvent an arbitration agreement by asserting its invalidity, because that dispute in and of itself falls to be determined by a tribunal.
Yes.
And once one reaches that position, we say that the application of Article 13 to this case should be relatively straightforward, because the parties to the assignment agreement are the second and third defendant, and the claimants have no independent legal rights under the terms of that contract. Their only capacity in this case is through the fact that they're members of the second defendant. Any dispute regarding the rights under the contract, which is obviously affected by the validity of that contract, as between the second and third defendant, are arbitrable. And that includes expressly, within the scope of the arbitration clause, any dispute concerning the formation, performance, interpretation, termination, or invalidation of the agreement in any manner whatsoever. And when one looks at the relief that's sought in these proceedings, i.e. a declaration that the assignment agreement is void or voidable, and therefore setting it aside, the subject matter of the dispute is quite clearly the subject of an arbitration agreement, and the court in those circumstances has no choice but to stay or dismiss the claim against the third defendant insofar as it relates to the validity of the assignment agreement. And really, there are a number of different
But
levels.
not necessarily, it's saying that, do you mean it should stay the proceedings insofar as it relates to the validity of the agreement, but not insofar as it relates to the claimant's application to set aside the agreement under the regulations?
We actually say both. I can see the point you're making. It's certainly much clearer when it comes to the question of authority. But when one distills what, I'll work through this, but when one distills what the basis of the claimants seeking to set aside the agreement is, we say that that isn't enough for members of a company to seek to progress independently of the company a claim which seeks to invalidate a contract executed by the company. And the reason for that is essentially that it's not for the members to simply contract into resolving the company's disputes through another forum.
But Regulation 79.6 is in effect a statutory exception to the usual common law position, isn't it? It
Yes.
gives a statutory right to a member to set aside the agreement.
Not quite, I think, is our answer to that. So it's been accepted in it's accepted previously by the claimants and proceedings that the DIC court isn't the default court of competent jurisdiction for the operation of the DCC regulations. I think that was in Mr. Montague-Smith's skeleton for the hearing back in March, and then I think it was repeated in the skeleton for the April hearing. I'm sure he'll correct me if I'm wrong, but it's I can dig out the reference to that. That's right. We don't dispute the fact that the members in the articles entered into a contract saying that if any dispute arises between us, we will resolve that in the DIFC court. In the same way that articles of association often would say that disagreements between members for a variety of reasons are arbitrable, maybe it's for confidentiality reasons. The problem with the way that the claimants have presented their case is that, having relied upon a contractual opt-in to the DIFC courts, it is caught by essentially a set of parameters in which the DIFC court has jurisdiction. And I'll show you the jurisdiction clause arising in the articles later. But it's if there is a dispute arising under the articles, the DIFC court has jurisdiction to resolve those issues as between members. And the way that the case is pleaded is that the articles, as a contract between members, and which can be adjudicated before the DIFC courts, contains a provision which incorporates the DCC regulations, at least insofar as they don't conflict with the express terms of the articles. And so the claim to set aside is premised on a an asserted contractual right. So as members, we have a contractual right to sue you, another member, for your breach of the regulations, and in doing so, we'll seek relief. And we would say, on a couple of levels, you can't consider the set-aside agreement as being one which the members are entitled to pursue. It's the company who have the right to litigate whether or not agreements that they enter are valid or invalid. You cannot, as a member of a company, come to a private arrangement or a contract as between members, which you then assert give you the right to interfere with the operation of the company in that way. So whilst we say it's perfectly permissible for the claimants to bring a claim against the first defendant, asking him to account, for example, that's one thing. But what they can't do is have that second limb, which is deal with questions of validity, because those are in the company's gift and those are arbitrable. And even if it wasn't a mandatory stay, although we say it is, the court should nevertheless stay that portion of the claim as well, where it more properly is a claim to be pursued by the company. I've got a little more to say about that, but that's a long overview. But I suppose, first of all, if I may, Your Honour, if one just sticks not with these issues of company law and proper claimant and so on, if you just stick within the framework of arbitration in the DIFC, the position frequently adopted by the court is it's generally one which takes a positive approach to the enforcement of arbitration agreements. And so, for example, Article 13 largely mirrors the UAE's obligations under the New York Convention. And we would say that the starting point for Your Honour's consideration of this portion of the third defendant's application is you should strive to uphold arbitration agreements. And a good example of that approach from the court was it's referred to in my skeleton, it's not in the bundle at the moment, but I'll send you the references. But it's International Electromechanical Services and Alpha TAN. And for context, when you read this case, this is one which was decided prior to amendments being made to the DIFC arbitration law. And it used to be the position that Article 13 only applied with respect to DIFC seated arbitrations. And so the court was considering whether or not it should stay proceedings in respect of a non-DIFC arbitration. That's now changed, where Article 13 and the mandatory stay provisions operate on all arbitration agreements. So that's why the court in this case was exercising a discretion to stay rather than operating a mandatory provision of law. But in either event, one can see that the approach is pro-arbitration. So the facts of the case are, it's in relation to the construction of Alpha TAN Tower. You've got the second defendant, who's the employer. The first defendant's the main contractor, and the claimant was a nominated subcontractor. So it had a contractual relationship with the first defendant, the main contractor, and it was seeking recovery of works done under that subcontract. It brought a claim against both parties and the defendant sought a stay, because the subcontract between the claimant and the first defendant had an arbitration agreement, and there was no arbitration agreement between the claimant and the employer. The relevant bit of the court's analysis starts at paragraphs 132 and 133. As I say, I'll provide you with these extracts. But it refers, first of all, to the court's inherent jurisdiction to stay proceedings, which is said to be a general one that extends to granting stays that serve the interests of justice and to prevent abuse of the court's processes. This jurisdiction would therefore permit a stay of the proceedings against the second defendant, despite there being no evidence of an arbitration agreement in existence between it and the claimant. The question, of course, is whether that jurisdiction should be exercised. It then refers to English Court of Appeal authority, a case called Reichhold and Goldman Sachs. It says in that case, the claimant had contracted with the parent company to purchase a subsidiary. Pursuant to an arbitration clause in the sale and purchase agreement, the claimant subsequently brought an arbitration against the parent company for breach of warranty as to the accuracy of the subsidiary's accounts. The claimant also brought an action in the English courts in negligent misstatement against the financial advisors which had advised it in connection with the purchase. The financial advisors didn't have an arbitration agreement with the claimant. Nevertheless, they successfully obtained a stay of proceedings pending the outcome of the arbitration against the parent company. And what the court then does is list some of the relevant factors that the court can take into account on that discretionary exercise of whether to order a stay. Those include, so I'm just going to read two of them. Bullet point 2, which is the natural and most efficient way of pursuing a remedy was by pursuing a claim against the parent company. This is a reflection of the position in the Reichhold case, I should say. In paragraph 4, in contrast, the claim against the financial advisors was more complex, and it was not clear why the claimant would want to pursue this claim in preference to the arbitration. And so for those 2 points, we'd say that amongst the other considerations Your Honour will have when it comes to some of the points I'll make about discretion later is what is the natural way of pursuing the claim? And 2, if there is a risk of increasing complexity by circumventing arbitral process or the normal process, that's a factor which weighs against proceeding. In the IES case, that's the DIFC case, the court exercised the discretion to stay so that the arbitration could proceed first. And that happened notwithstanding the fact that the claim between the claimant and the first defendant wasn't subject to that arbitration agreement. And that's the same position in the English Court of Appeal judgment, the Reichhold case that was cited. So there the court stayed the negligent misstatement claim against the financial advisors to allow the arbitration for breach of warranty to proceed first. So even in cases where a stay wasn't mandatory and the court was exercising a discretion, the approach of the court is to stay proceedings in favour of permitting the arbitration to take place. And that's even in circumstances where not all of the parties to the litigation are parties to the arbitration agreement. And we said that that's the sort of pro-arbitration approach one expects to follow under Article 13. The second reason we say it makes sense that there should... I'm sorry, Your Honour, it might be you speaking, but I think you're on mute.
You're quite right. So do you say this applies to the claimant's claim to set aside the agreement under Regulation 79.6?
Yes.
So that should, because now that cannot be the subject of arbitration, can it?
Well, on our construction of Article 13, yes, because and for the cases I've just taken you to, so the question that one frames under Article 13 is the subject matter of the dispute subject of an arbitration agreement? And by reference to the statement of relief that's being sought, which is a declaration that the agreement is void or voidable and should be set aside, that is the same subject matter as the arbitration agreement, because it says that this arbitration agreement covers questions of invalidity, nullification arising however. And so when the like subject matter applies...
Not setting aside under Regulation 79.6 because a member of the company didn't declare their interest at a meeting. That's only covered in the claimant's claim, isn't it? And can only be part of the claimant's claim. It can't be part of the any claim between the second defendant and the third defendant.
There are 2 points I make in the context of arbitration. There's another point which I make later, which comes to the nature of the relief sought. The first is that we say when you read the words subject matter, the relevant subject matter here is the validity or not of the assignment agreement. And where that is the subject matter, it might make a difference between the approach Your Honour takes on Article 13, because there are two options. One is you can stay, and one is you can dismiss proceedings. And there must be a logical reason why there is a difference. So, for example, if the subject matter is common subject matter, but if after the resolution of the arbitration there remains an issue as between, in this case, the claimants and the first defendant, then it might be that the more appropriate form of order in that sort of case would be for the court to say, well, I'm going to stay it rather than dismiss it. But we would say that it doesn't ultimately impact the operation of Article 13, which is that it bites, and so the court has a decision to make one way or the other. The points which I'm about to come on to deal with why, in the context of an arbitration agreement like this, that should make sense, by reference to other provisions of law about who should bring these sorts of claims in the first place, and I'll come to that. And then the third point, which I'll circle back to at the end, is when it comes to Your Honour's exercise of a discretion in this case, so if you're considering form non-conveniens or desirability, one of the things that you can take into account is the fact that what is sought by the claimants is a declaration that these agreements should be void. And of course, whether or not a court makes a declaration isn't in and of itself discretionary. And amongst other things you're going to consider about that sort of relief is whether it's proper or reasonable for the DIFC court to adjudicate this issue on validity when actually the proper forum is arbitration and it's in proceedings as between the second and third defendant by way of derivative action if necessary. And those are linked points. So we say that the second reason the operation of Article 13 in this sort of a context makes sense and why there should be a stay in favour of arbitration is the claimants are not only seeking to circumvent that valid arbitration agreement, but also a number of other established principles. For example, privity of contract, which generally protects contracting parties from interference by third parties, but also the concept of companies as distinct legal personalities and distinct from their membership, which is a concept which has been applied by the DIFC court relatively recently in Camel and Kawa, but actually I think it was a principle that was referred to in the first trial that came into the DIFC in Dutch Equity Capital Partners, which again is not on the bundle, I'll include it in my list of references. But they referred back to the English authority in Prudential and the classic definition of the rule in Foss and Hardbottle. I'm reading from paragraph 144 here and summarise the relevant propositions, which are: 1, the proper plaintiff in an action in respect of a wrong alleged to be done to a corporation is the corporation. 2, where the alleged wrong is a transaction which might be made binding on the corporation and all its members by a simple majority of the members. No individual member of the corporation is allowed to maintain an action in respect of that matter, because if the majority confirms the transaction, there's no valid reason why the company should not sue. 3, there's no room for the operation of the rule if the alleged wrong is ultra vires the corporation, because the majority of its members cannot confirm the transaction. 4, there is also no room for the operation of the rule if the transaction complained of would be validly done or sanctioned by a special resolution or the like. 5, there is an exception to the rule, which is where what has been done amounts to fraud and the wrongdoers are themselves in control of the company. In this case, the rule is relaxed in the favour of the aggrieved minority, who are allowed to bring a minority shareholders action on behalf of themselves and all the others. So the rule is that the proper claimant is the company, not the shareholders. Where there are exceptions to that, what you would expect to see is, in the case of a shareholder action, that would be brought by way of derivative action, which isn't the case here. And we say that gives rise to problems for the claimant because at least one aspect of their case has nothing at all to do with the DCC regulations, and that is, as Your Honour identified, the assertion that the assignment agreement is invalid because the first defendant didn't have actual or ostensible authority. And there's no explanation at all as to how the claimants, under the terms of the Articles of Association, could have any standing to bring that sort of a claim. And so that can't be a basis for the court to interfere with an arbitration agreement where that agreement covers all disputes concerning its validity. If there is an issue like that, it's an issue between the second and third defendant, in which case it has to be arbitrated. And as I say, when it comes to the set-aside portion of the claim, we also say that that doesn't give the claimants standing in respect of questions concerning the validity of that agreement. So their members, the first defendant's a member, D2 and D3 aren't clearly. As I said, when you break it down, the basis of the claimant's asserted case is contractual. They rely on the articles and the incorporation of the DCC regulations into the articles as meaning in turn that the disputes between them fall to be resolved by this court because the court is considering a dispute between members. The claimants don't assert in this case that they fall within one of the exceptions to the normal rule, which is that a claim by a company is in the gift of the company. And we say that members can't simply contract out of rules of law which govern the independent legal personality of corporations, or the enforceability of arbitration agreements, or privity of contract, in order to give the membership free rein to seek to invalidate otherwise prima facie valid acts of a company. So that's our way of saying that the basis isn't, when you properly analyse it, statutory. It's an asserted contractual right, but not one that the members are entitled to assert. And as I gather, the principal response to this portion of the application from the claimants is Article 13 can't apply because the claimants aren't a party to the arbitration agreement. That, respectfully, is irrelevant because the arbitration law doesn't say that you must be a party to the arbitration agreement. It's actually cast in quite different terms to what appears in other jurisdictions. For example, in England, I think that Section 9 of the Arbitration Act says a party to an arbitration agreement against whom legal proceedings are brought can refer to arbitration. So it's quite specific in separating out the concept of a party to an arbitration agreement as compared with a party to the court proceedings. But if one looks at what is set out in Article 13, the only reference to a party refers to a party in the context of them submitting a statement on the substance of the dispute. So it's talking about a party to the proceedings, not a party to the arbitration agreement. And in any event, even if that wasn't right, as I've already said, the court, even beyond the reach of Article 13, possesses an inherent jurisdiction to stay proceedings on discretionary grounds. And those powers were exercised in the IES case, and also the example I give you of the English court's approach in Reichhold. And in both of those cases, the court stayed proceedings, notwithstanding the fact that one of the claims that was before the court was accepted as not being subject to an arbitration agreement. And so whether it's mandatory or whether it's by operation of a discretion, we would say that the proper approach for the court to take here is to order the stay. There is a relevant arbitration agreement. It covers disputes arising out of the formation of the agreement and its validity. The proper party to have a say in its validity, at least in the first instance, must be the company, and it would be undesirable for there to be an arbitration in respect of an issue of validity over an arbitrable issue, where the court would nevertheless proceed on behalf of members pursuant to one of their contracts to make orders which affected what naturally must be a right of the company. And so a stay would be ordered on that basis. Like I say, we don't dispute that the claimants can bring the claim against the first defendant for an account, but to the extent that any of the pleaded relief seeks orders as to the invalidity of an agreement between the second and third defendant, we say the proceeding should be stayed, either on a mandatory basis or to the extent that one portion of it requires by an exercise of the court's discretion. The final part, which I think I can get through a little bit quicker because it's just a series of confined points, is the necessary and proper party / forum non-conveniens points. And I explained in my skeleton why it is that we take those points together, because in discretionary exercises like this, the tests are distinct, but of course there's a degree of overlap in what's going to be a relevant consideration for your honour.
And you've provided a list of what you say are the relevant factors in your skeleton, haven't you?
Yes. There might be a couple that I will touch on briefly in the authority just to draw to your attention, but yes, it's all there, and I don't think that there's a huge gulf between the parties on what the test is. It's really about what factors apply and what should weigh on your honour's mind as being factors militating for and against. Like I said, just a few bits of law. On forum non-conveniens, I think the parties are agreed. It's the Spiliada test. It's 2 stages. It's been summarised in Procedural, paragraph 23. So 1, what's the natural forum, i.e. the forum with the most real and substantial connection with proceedings? And 2, in the interest of justice, should there be a stay? And then when it comes to the question of joinder and desirability, we say that there are a number of other specific considerations that may be relevant to the exercise of your discretion. So, for example, what the court needs to have in mind, given the basis upon which it wields the power, is the important role that the court itself plays in policing the necessary and proper party jurisdiction. So when asking under RDC 20.7 if a party should be joined, the test says you consider, is it desirable to resolve the issues in dispute in proceedings? 2, is the new party connected to the matters in dispute? When you look at both of those limbs, the issues that it's referring to, so is the party connected to an issue in dispute, or is there an issue involving the new party? You have to frame that by reference to the issues in dispute prior to joinder. So there is a claim between the claimants and D1. That claim comprises the following issues. Is the third defendant a necessary and proper party to be joined for the resolution of those issues? And together with that, one of the relevant considerations is where the addition of another party adds to the overall complexity, it adds unnecessary complexity, or it adds issues beyond those already before the court. And those principles we derive from a case cited in my skeleton, Gaia River. Again, it's not in the bundle, so I'm going to have to read it and send it later. But it's paragraphs 11 and 12, first of all. Excuse me for coughing and struggling my way through, Your Honour. The kids are back to school and I've brought home everything that is associated with that. The paragraph 11 says, The new party in the present context of that case are the two companies, Rene and Salta. For that purpose, it is necessary to understand what the existing proceedings are and what the matters in dispute in those proceedings are. I've identified in broad terms what they are, and essentially the matters in dispute revolve around the existence or otherwise of the various agreements to which I have referred, and the extent to which those agreements were either performed or were unable to be performed as a result of the conduct which is to be allegedly attributed to the claimant and or Jacob International. It seems to me that this case can be resolved without the additional parties whom it is sought to join. These additional parties do not seem to me to add anything to the way in which the existing litigation is likely to be resolved. The position is that all of the parties and the defendants are within the same group, and it's not suggested, for example, that there's any particular evidence which is available to those parties which makes it desirable for them to come into existing proceedings. The real purpose of joining these additional parties is not, in my view, from what I've heard, to assist the court in resolving existing matters in dispute in proceedings, but rather to enable a contingent claim to be pursued against different parties. It does not seem to me that that comes within 19.2a, which is 20.7a. Sorry, 20.71, I think it is. But in any event, even if it did, I cannot see that there's any desirability of joining parties in those circumstances. The positions that none of the existing parties to the actions wishes to bring any claim against Acronym and Salta, the defendants, who are part of the same group, obviously have no claim, and the defendant does not wish to advance the claim itself. The purpose, as I've said, is to enable contingent claims. So the question that's relevant here is, do you need the third defendant to be involved? This is under the first limb of 20.7. Do you need the third defendant to be involved in order to resolve what is, in fact, a dispute between members, which has come before the DIFC solely on the basis of an agreement between members that they should litigate their disputes in that way? And much the same point applies to the second limb of the materially identical CPR test, which is the second question is whether this comes within 19.22b. There is no doubt, in my view, that this is a wider provision. It's clear, for example, from the decision, and it cites a decision in another case. It says, for the purpose of this provision, it is necessary to identify an issue involving the new party and an existing party connected to the matters in dispute in the proceedings, and that it should be desirable to add the new party so that the court can resolve this issue. This is paragraph 13, I should say. And in paragraph 14, in the final two sentences, it says, the position is that the court will hear plenty of evidence about that from the existing parties, and I do not see why there is any desirability of these new parties coming in to lend their weight to the resolution of any issue, since it's not desirable to add the parties so the court can resolve that issue. The requirement for the exercise of jurisdiction under the second limb is not met. And then finally, in reaching its conclusions about that, what the court says there in paragraphs 15 or 16, I've looked at the question of desirability in a narrow way so far, but it seems to me that even if there was jurisdiction under 19.2b, it is undesirable in the present case for the additional parties to be joined for a variety of reasons. And then the first cited is, it seems to me that their joinder would introduce unnecessary complexity into the present proceedings. So based on that, Your Honour can take into account not only what does the additional party add, but is what it's going to add actually just complexity. And then the final authority before I make the points I have to make is another English case, Lungo and Vedanta. It's a 2020 decision of the UK Supreme Court. And this is an extract of paragraph 20. Again, it's not in the bundle, but we can provide it. And this is a reference to the CPR practice direction, which deals with what it considers in a necessary and proper party sort of application. And it says it's common ground that by reference to those terms and well-settled authority, the claimant must demonstrate as follows: that the claims against the anchor defendant involve a real issue to be tried. If so, that it's reasonable for the court to try that issue. 3, that the foreign defendant is a necessary or proper party to the claims against the anchor defendant. 4, that the claims against the foreign defendant have a real prospect of success, and 5, that either England is the proper place in which to bring the combined claims, or there's a real risk that the claims will not achieve substantial justice in an alternative jurisdiction. Now, the rules framework in the CPR and the practice direction is different. Ultimately, this is a matter of the court's discretion. Is it desirable to join? And so we would say that those factors are also relevant. So you can take into account merits. You can take into account whether the DIFC is a reasonable or proper place to try the issues. And when you put those factors together, we say that the circumstances of this case weigh very strongly against the DIFC court's continued involvement in this issue. And I'll just list them. First, it isn't reasonable for the DIFC court to assume exorbitant jurisdiction when its only real connection to this case is derived from a single narrow jurisdiction clause contained in a contract that applies as between members. So that's the articles. The relevant jurisdiction clause there is at page 856, I think. And what it said, this is Article 28. These articles are governed by and shall be construed in accordance with the laws of the United Arab Emirates. 18.2. The DIFC courts have exclusive jurisdiction to settle any dispute arising from or connected with these articles, including a dispute regarding the existence, validity, or termination of these articles, or relating to any non-contractual or other obligation arising out of or in connection with these articles, or the consequence of its nullity. So under that agreement, plainly, and we don't dispute, that the claimants as members can bring a claim in the DIFC against the first defendant, who is also a member who's bound by the articles. That's all well and good. But the third defendant isn't a party to the articles. It isn't a shareholder in the second defendant. It has no role in the management of the second defendant. It isn't even a parent or a subsidiary of the second defendant. It's not a DIFC company. The second defendant also isn't a DIFC company. And the third defendant has nothing to add to a shareholder dispute, which the first defendant can't already add. So on that basis, when you actually go through what the gateway through the operation of the rule is, it's neither necessary to join the third defendant, nor is it reasonable for the court to assume jurisdiction over the third defendant, when fundamentally the basis of the court having any jurisdiction over any of this is so incredibly narrow to begin with. The second broader point is that we say that the merits of the claims advanced are weak, and that is relevant. The claimants aren't a party to either of the relevant contracts. As shareholders, as a matter of law, they're not the proper claimants in a case where the normal course and the more natural course, if you're a minority shareholder, is to bring an action on behalf of the company through a derivative action. On any analysis, the arguments that the claimants make about authority have nothing to do with the articles, nor do they have anything to do with the DCC regulations, and they have no standing to make those sort of assertions for reasons I've already given. And if there are any issues concerning the validity of the assignment agreement or purchase order, it isn't desirable or reasonable for the DIFC court to try those in an action brought by shareholders. Because the shareholders, of course, aren't parties to the contracts in the ordinary course. They're asking the court to exercise a discretion to award declaratory relief in respect of those contracts. And you'll have seen that I've cited in my skeleton a case called, it's a UK case, Federal Mogul Asbestos Personal Injury Trust. And the principle that we derive from that is to say that shareholders can't, shareholders or non-parties to contracts to put it even more broadly, a non-party to a contract cannot ask the court to exercise its discretion and award declaratory relief when the contracting parties are not themselves in dispute. So again, not in the bundle, unhelpfully, but I'll provide you with the reference. It's paragraphs 94 and 95 of this judgment. The context of that case is whether the trust could get declarations regarding the obligations of reinsurers concerning their settlement of asbestos claims against other parties. So the trust wanted to advance claims against a defendant. They wanted to know, will the reinsurer cover this? And what the court says is, in summary, I accept the main thrust of Mr. Butcher's submission that a person not a party to a contract generally has no locus, save perhaps in exceptional circumstances, to obtain a declaration in respect of the rights of other parties to that particular contract, at least where the contracting parties themselves are not in dispute as to their respective rights and obligations. As Mr. Butcher pointed out, that is consistent with the ratio of a judgment discussed in that case, a case called Meadows. He says, although I fully accept that the law has moved on since that case, it seems to me that this remains the general position, at least as a matter of the court's discretion, even after the more recent cases cited above, including the Rolls-Royce case, in particular, as emphasised by Lord Justice Aikins at paragraph 2 of his summary and of the applicable principles in that case. There must, in general, be a real and present dispute between the parties before the court as to the existence or extent of a legal right between them. Although at the risk of stating the obvious, I fully recognise the importance of the words in general. But in the present case, the court found that there were no exceptional circumstances. And so one important aspect of Your Honour's considerations is, well, the claimants as contracting parties, as parties to a jurisdiction clause that applies between members, are asking the DIFC court to make declarations concerning agreements that otherwise have nothing to do with the DIFC. And in relying on the exercise of the court's discretion in that way, they subject themselves to the criticism that the court should, we say, be extremely reluctant to award that sort of relief, even in the normal case, even before all of the other problems that I've outlined, when the questions of validity actually fall to be determined as between the parties to the relevant contracts, not their shareholders. So one can add that to the list of all of the other legal principles that the claimants have to chart their way through in order to avoid the normal way of presenting a claim. The third point is a relatively brief one. Part of the assertions made before the court is in connection with the ownership of the intellectual property in MCC. I think there are 2 points about that. One, procedurally, that is clearly a complicating factor because on the claimant's pleaded case, the relevant rights were vested in the second defendant and subsequently the third defendant. So the potentially relevant list of substantive law there is UAE law and Malaysian law. But we also have a question of how either company came to acquire those rights in circumstances where we only currently have one positive pleading about authorship of MCC, which is by an Egyptian national and an Egyptian resident. But what's clear on any analysis is that when it comes to how these rights are vested and held, we're not talking about issues of DIFC law. We are talking about potentially competing issues of foreign law, and that's precisely one of those sorts of factors which add complexity. And one can add to that an additional problem when it comes to how these rights are held, which is instead of a case before the DIFC court reducing the risk of there being conflicting judgments, the claimants have actually gone about things in a way which would make conflicting judgments, if the DIFC court proceeds, a near certainty. Because, in fact, as Your Honour saw back in April when we had our last substantive hearing on this matter, there are already existing proceedings before other courts in which the claimants expressly assert that MCC is owned by another entity, HI Egypt, and the bundle references, I know because I've tried before that these take a long time to load up. But the bundle references for that are page 1264, where we can see one of the petitions put in by the second claimant on behalf of the Egyptian entity Health Insights Software Design. And at page 1267 of that petition, in which there is a positive assertion that Medical Cloud Care is owned by HI Egypt. So if one of the factors that the claimants point towards in telling you that declining jurisdiction risks conflicting judgments, the obvious response to that might be to ask why it is the claimants have brought a case before the DIFC court which conflicts with cases that they've already positively asserted elsewhere, and why they're seeking a declaration about the ownership of those rights which would conflict with what has been claimed elsewhere. I'm on my fifth point now, which is none of the parties have any material connection with the DIFC. The claimants are Saudi and Egyptian nationals resident outside the UAE. D1 is an Egyptian national resident outside the UAE. D2 isn't a DIFC company. D3 is a Malaysian company. Health Insights doesn't conduct business in the DIFC. And the sole connection in this case is an opt-in by members in the articles. And that's even in circumstances where the DIFC courts aren't the default court for disputes under the DCC regulations. And then as a matter of procedure, I think we're on 6 now, there's no procedural benefit to joinder or assuming jurisdiction in this case, or factors which would ordinarily point towards the DIFC court being particularly well placed to adjudicate the issues. So there's no benefit from the point of view of convenience or expense because the relevant witnesses aren't based in Dubai or the DIFC. The business being carried out is in other jurisdictions. None of the substantive legal issues appear to fall to be determined by reference to DIFC law. And the addition of the third defendant increases the complexity of proceedings. Its additional parties, its additional issues concerning ownership. It will include most likely issues of foreign law needing to be considered. And the DIFC court isn't even in the advantageous position of being first mover on these issues because the DIFC claim is one amongst a number of different claims that have been commenced by the claimants in other jurisdictions. So it's not like the DIFC court is even going to be the first one past the post when it comes to the resolution of those issues. And we would add to that that where we've got a shareholder dispute, which it is, that's what the basis of the court's jurisdiction in the first place is. Why is it that the third defendant is going to add anything to that? The first defendant is the individual who has access to the evidence that's relevant to the claims as originally pleaded, which are the relevant issues on the application of Rule 20.7. And it's really difficult to see what the third defendant adds to any of that. And then the final point is connected to what we've said. Not only is there no connection to the DIFC, but the more natural forum for a claim against the third defendant, the place where there is a more natural connection into the more natural jurisdiction would be Malaysia, because on both parties' cases, the relevant ownership rights are at least currently vested in a Malaysian company. The claimants say that the assignment agreement had that effect, or at least that's what they say in these proceedings. And the first defendant says he's the author and that the third defendant acquired rights to MCC from him. And that is a far stronger indicator of Malaysia being the natural forum as compared with the DIFC, where genuinely there isn't a single factor which points towards the DIFC court being a natural forum for the adjudication of issues concerning D3 or its ownership of MCC. There's no nexus between the proceedings against the claimants and the third defendant at all. And when it comes to your discretion, Your Honour, those are all of the factors that we say mean that it is not desirable to join the third defendant. And even if one took the view that the third defendant was already joined and that the court had jurisdiction, that it should unjoin the third defendant and that the court should decline jurisdiction and form non-conveniens grounds.
Yes.
And thankfully that's it, Your Honour.
All right. Well, thank you. Now, I see, depending on where you are, we're now 2.5 hours since we started. I think it might be sensible to take a break. Question is how long that break should be.
Well, Your Honour, we're in your hands. I'm just
Yeah.
conscious of the court staff. It's
Yes.
1:40 in Dubai, and
Yeah.
no doubt they have lunches and potentially prayers and all the rest of it that need to be attended to. I am a bit concerned about the amount of time my friend has taken. It's 2 hours and 40 minutes, in fact. If I was to take anything like that, the chances of getting through really even this application are pretty limited. But that having been said, I think in fairness to the court staff, my suggestion would be that we reconvene maybe at 1/4 the hour to give them 35 minutes.
Yes. Yes, I think that seems sensible. So that that would be 2:15 Dubai time.
Yes.
So we'll do that then. We'll now adjourn to 2:15 Dubai time, whatever that time is, wherever we all are.
Thank you, Your Honour.
Thank you. All right. Are we ready to start again?
From my side, yes, Your Honour.
All right, Mr. Montague-Smith, it's you have the floor.
Thank you very much. And before I start, I am also suffering from some of the technological problems that are afflicting everybody, unfortunately. What I've got is a PDF, which was provided, I think, by the court, but the numbering is slightly different to the court bundle. But I will do my best. I think I've got the right up-to-date numbers, but apologies in advance. The other thing I should mention is there have been some slightly pointed questions from my learned friends instructing solicitors about why my learned friends authorities didn't make it onto the bundle. Some of them did, some of them didn't. And just to put your mind at rest, as I understand it, the system crashed while that process was being undertaken at my end, or my solicitor's end. So there's no, I hope, suspicion of any sort of tactics, and certainly nothing that I'm aware of.
I think we're going to have to muddle through, Mr. Montague-Smith.
We'll do our best. Thank you. All right. I'm going to take the issues in a slightly different order to my learned friend, because what I propose to do is I will deal with jurisdiction first, and then I will deal with the arbitration slightly separately, because there are somewhat different issues that apply. But when dealing with the jurisdiction, I'm going to try to deal with the substance of it first, and then go on to look at whether or not the position is changed by all of the procedural points that are raised by my learned friend. It seems to me that my learned friend's position on the substance comes right at the end of all his submissions, buried under a set of procedural objections, which are really intended to indicate that you should never actually have the opportunity to decide whether or not it's desirable to have the third defendant as a party to these proceedings. But just preface those. I'll preface those submissions just with just a small reminder of the context. As your Honour's aware, the claimants and the first defendant and the second defendant agreed that disputes arising out of or related to the articles of association of the first defendant would come to this court. And that's not unprecedented for DCC companies. So that's in effect a facility that's available to companies that are established in the DCC, that this court becomes, in essence, the court of the place of incorporation. And that can give rise to a degree of complexity, but hopefully not one that gets in the way of this court effectively stepping into the shoes of the court as the place of incorporation. Now, my learned friend says, well, that's a very slender basis for which this court should find jurisdiction. He says that in his skeleton argument, and also orally. But I mean, I make the point that about half the business of this court is opt-in business, and opt-in has been available for 12 years. There's nothing slender about relying on jurisdiction agreements as the source of jurisdiction for this court. It's not unusual. In fact, in some years it's the majority, in some years it's just under the minority, but it's something like half of the business. But I just make this point, having made that agreement to this court's jurisdiction, what the first defendant is now trying to do is take every possible step to block and frustrate this court in giving appropriate assistance to the claimants. And that includes, as Your Honour has heard, the first defendant relying on an arbitration agreement that he effectively agreed with himself. And trying to take points about my clients not having standing, and yet he is relying on an arbitration agreement that he is not party to, and the claimants are not party to. So not only is he trying to enforce an arbitration agreement against a non-party, he himself is a non-party, and the second defendant is not in a position, and my learned friend has made clear he doesn't appear before you on behalf of the second defendant, and properly so. But so it is an extraordinary position to take, that the first defendant can admittedly agree with his company, with the other shareholders, that this court will have jurisdiction, and then rely on an agreement which we say is void because he had no authority, but in any event is voidable or void because it was done without a declaration, to try to say this court can't deal with it. Somehow there has to be an arbitration, presumably between himself and a company, or a company, two companies that he controls in practical terms. And the position on the ground in relation to this company is really troubling, we say. So Your Honour has already found that the resolution that the claimants passed to remove the first defendant and replace him as the general manager with the second defendant, Your Honour has already found that that was validly resolved. And despite that, the second defendant continues to block the practical steps which are required for my clients to take control, the second claimant in particular, to take control of the company. So the first defendant won't change or hand over the credentials that are required to get access to the company portal. And so the DDA's register says that the first defendant remains the general manager. He's not in fact the general manager, because the reality of the situation follows the resolution. But my learned friends instructing solicitors have taken the position that they're still entitled to act on behalf of the second defendant. They don't. My learned friend doesn't do so today, but in correspondence that is their position, and we say that position is extraordinary. And they have been warned that they have and had no authority to do so. But no steps have been taken, for example, to place the company and the control of the company into the hands of a third party, to provide an independent custodian for its interests. And I would just show you one piece of correspondence, if you haven't seen it, Your Honour, just to see quite how extreme the position really is. And I'll show you a response from my learned friend's solicitors to letters from the second claimant, who's saying you're not instructed to act. And the response to that was met with threats of criminal prosecution by the solicitors themselves. And I'll just show you that. It's at page 720 of your bundle. I think it's 720, but if we're testing my dual numbering system now. I've got it at 727, but you should see an email from Mr. Karen or Ms. Karen Seif, or S-E-I-F. I do not know that person, but it's to Mr. Al-Shafai. And this is in response to the second claimant's correspondence saying you are not authorized to act. And I'll just you can read that for yourself. But if your honour just looks down to halfway down the page, this is an email from my learned friend solicitors. You are hereby put on notice that false impersonation is a crime that is punishable under UAE law, and you are requested to cease and desist from holding yourself out as the general manager of Health Insights in contradiction to the company's official records. Our firm reserves all its rights to bring any claim against you in your personal capacity, as well as in any other capacity that you may hold, including inter alia for any damages, including reputational or costs that we encounter because of your unacceptable threats and intimidation attempts. We say that is a quite unacceptable position for lawyers who are acting and registered to act in the DIFC courts. And the position is being taken to bolster the first defendant's continuing and unlawful control of the company. And that is what is going on here. What is going on here is that this is a continuing attempt, and you see it with the set-aside application as well, to block the lawful actors from taking control of this company. And as I've said, the first defendant has agreed that the disputes between the shareholders and the company's management would come to this court, and he's trying to prevent that, and that is also part of that strategy. Now, there are a number of points we would make. I'm sorry, could I just ask everyone else who's on the call, there's a KS, I think, who just needs to mute. Karen Safe, I think that is the person we just mentioned. Thank you. There are a number of points to make in response to the jurisdiction application. So we have points about the timing of the application, the way it has been made, that we say means that it's too late to bring that application. My own friend has a number of procedural points saying, well, we can't ever have these things determined. Ultimately, we say the test for jurisdiction is whether the third defendant has been joined to these proceedings. That's already happened. There is no application to set that order aside. There is no appeal against that order. In his submissions, my learned friend mentioned another way that one might reverse the joinder of a party, and that was an application under Rule 20.8. Rule 20.8 says the court may order any person to cease to be a party if it is not desirable for that person to be a part of proceedings. There is no application under that rule either. And as I mentioned, we do say it is too late for my learned friend's clients, for the third defendant to dispute jurisdiction generally. But fundamentally, even if all of that was wrong, so even if you start again, this is a case we say where the court plainly would have jurisdiction. And I'm going to deal with that point of substance at the outset, because the test, the substantive question that this court would ask itself in determining whether to exercise jurisdiction over the third defendant is whether it would be desirable. Is it desirable? The test is at Rule 20.7. If your honour hasn't looked at it in the course of these proceedings or this hearing, it's worth just doing that, because I think my learned friend has described it as the necessary or proper party test. That is the test in England under one of the service out gateways. And so there is an analogy between the English test and the DIFC test, but the words are not necessary and proper. It doesn't have to be necessary. The only question is whether or not it is desirable for one of the two purposes that are identified in Rule 20.7. So is it desirable to add the new party so that the court can resolve all the matters in dispute in the proceedings? Is it desirable, or is there an issue involving the new party and an existing party which is connected to the matters in dispute in the proceedings, and it is desirable to add the new party so the court can resolve that issue? Now, if that test is met, then the court has jurisdiction. That is the effect of the Nest Investments case in the Court of Appeal. I appreciate my learned friend says, well, Nest Investments tells you that there needs to be some form of application to join before you can look at that question of desirability. I'll come on to that. That is not what Nest Investments says at all. It doesn't. My learned friend took you to the first instance reasoning, which was overruled effectively, albeit they don't. I mean, in Sir Jeremy Cook obviously wasn't particularly interested in the procedural intricacies of it all. He went straight to the what is the test? Is it satisfied in this case? And we say that must be the right way to do it. It would be unfortunate if the result was that Your Honour found it was desirable for the third defendants to be parties to these proceedings, but that somehow or other there's just no way to get there because of the way in which the timing of applications and so on. That's not the law. It shouldn't be the law. Certainly there's nothing in any of the authorities which suggests it's the law, but I'll come back to that. But and also important is the fundamental rationale for why in Nest Investments the Court of Appeal found that this particular provision of the rules confers jurisdiction. And so it is worth just looking at Nest for that purpose, even if we don't look at it at this stage for the sort of more procedural and technical points. If Your Honour would turn to page 1786, 1786, and it's paragraph 53 and 54 of that judgment, which is relevant. And here the Court of Appeal is looking at the question, is this a rule which is intended to confer jurisdiction? And so looking quite broadly at that question and answering it in part by reference to the policy considerations. So paragraph 53, Sir Jeremy Cook says, in such circumstances, the question of policy and purpose in the rule in question and the rules as a whole fall for consideration. There are overwhelming reasons for the court to give the rule a wide meaning. There is self-evidently merit in a court having something in the nature of a necessary or proper party rule, so that matters in dispute can be decided between all the relevant parties, without the risk of inconsistent decisions by different courts at different times, with all the inherent additional costs and inconvenience involved. As the claimants point out, the effect of the refusal to make an order in a case such as the present is to render the DIFC courts effectively incapable of trying a claim with multiple defendants from different jurisdictions, where the gateways cannot be satisfied in respect of each. Paragraph 54. Public policy weighs heavily in favour of the court having such a power because it aids in the administration of justice. It is a power which is found in the rules of court in many jurisdictions, however differently it may be expressed. The object is to prevent unnecessary duplication of litigation in different jurisdictions and to facilitate the resolution of disputes consistently between multiple parties where common issues arise for determination. The overriding objective of the rules, as expressed in RDC 1.6, is to enable the court to deal with cases justly, which includes, as far as practicable, saving expense and so forth. And goes on from there to say that the narrow approach would be in conflict with that objective. Now, this jurisdiction application is made only by the third defendant. And so the claims against the first and second defendants will continue in their current form. And those include the claims to set aside the purchase order, that's the prior order, and to set aside the assignment agreement. The first defendant has filed a defence which responds to all of those claims. And so we would say it is so obvious as to go without saying, really, that it is desirable to add the third defendant in order to resolve those claims. And we do say what is striking about my learned friend's approach to this hearing, both in writing and orally, is that that fundamental issue, is it desirable, is buried under a swathe of what we say are unmeritorious technical points. So what I was going to do is just run through actually what he says about it, both, and I'll do it by reference to the way that he presents it in writing, but also pick up the additional points that he makes orally. But the first point to make is that my learned friend says, well, none of the other JAL gateways are engaged, and that's what he says on page 7 of his skeleton argument running from paragraph 24. And he repeated that position today. Now, in fact, as you go down his list, he goes through the various gateways that are available under Article 5.1 and 5.2 of the Judicial Authority Law. And of course, in relation to the third defendant, the gateway we rely on is Gateway E, but not on the basis of anything that is said in his skeleton argument. The point about nest investments, or the point resolved in nest investments, is that Article 5A1E, when combined with Rule 20.7, confers jurisdiction onto the court over claims where that test is met. So this ultimately is a series of straw men that you've got put in front of you. And of course, the whole point of nest investments and this particular gateway for jurisdiction is that it only matters when none of the other gateways are available. So the fact that none of the other gateways are available is a necessary requirement for this court to have any interest in whether or not this particular gateway operates, and therefore it's completely irrelevant to the question of discretion and desirability. After that, you will see in the skeleton argument, and what my learned friends' oral submissions were mostly concerned with, or to a large extent concerned with, are submissions about why he says no application was ever made. He says under point 20.7, but really the issue must be for Joinder, and I will deal with that. But we say that is hardly getting to the heart of the matter that Your Honour has to consider. You then have running for another 3 pages or so, starting on page 10, a series of complaints about the pleadings, and then you've got the arbitration agreements arguments, which is a separate issue. So it's not actually until page 20 of the skeleton argument that you get anywhere near the central question, which is the desirability of the third defendant being a party to the claims that there are. And it's wrapped up as a combination between desirability and forum non-conveniens. And so he mixes those two arguments together. And of course, the test is the same, but the test is different, but the solution is similar. And fundamentally, what the problem with my learned friend's submissions is that this court will have these claims, all of them in their current form, being advanced against the first and second defendants, come what may. The application that is being made by the third defendant cannot prevent that. And indeed, the defence is there. Once you start from that position, you ask yourself the question, is it desirable that the third defendant be added to those claims? Or is it better, as my learned friend would have it, that the action against the third defendant go off to Malaysia? Because that is where he says is the appropriate place for a claim against the third defendant. So as between the claimant and the first two defendants, there is no dispute before the court that the court has jurisdiction over those claims. And therefore, as I say, that those are going to go ahead. So if one considers the alternative approach that my learned friend suggests, leaving aside, let's start another claim in Malaysia, what will happen? Because my learned friend says, oh, well, the third defendant hasn't got anything to add. That rather undermines his points about additional complexity, about the need to worry about where the witnesses are and all the rest. But what will happen is, if we are right in our claim, the court will get to the end of these proceedings, will find that, yes, those agreements need to be set aside for the reasons that we put forward. And the third defendant will simply say, well, that's all very interesting, but I'm not party to those proceedings, and therefore I'm not bound by anything that you have found. So in order to make this bite against me, the third defendant, you're going to have to do it all over again. And that will be what is the result of the procedural approach that's being urged on you by my learned friend. Now, is that a desirable outcome? And we say that is precisely the consequence that the rule is intended to avoid, as explained in Nest Investments. Now, I hesitate to put words into Your Honour's mouth, but I would suggest that that is likely why Your Honour was the one who suggested in the first place that the third defendant be joined. Now, this arose in two ways. Firstly, before the hearing, Your Honour sent a message to the parties saying, I'd like to know what your answer to this is, please. We addressed it in skeleton argument as to how we could do this action in relation, at that stage, just its right to the assignment agreement without the third defendant being a party. And Your Honour indicated in no uncertain terms that you had yet to be convinced. I think those were your words at the first hearing. And that is why, in that context, I proposed that the third defendant be joined. And given that history, we didn't really go through the detail of why the third defendant should be joined. But it seems in our submission, the reason for that is that it was pretty obvious. Now, there is a difference between whether it's necessary for the third defendant to be joined and whether or not it's desirable for the third defendant to be joined. My position was it's not necessary. And even if I was right about that, that wouldn't preclude me from saying it was desirable. I think Your Honour's position, though, as I understood it at the hearing, was in fact necessary to give them the opportunity to say whatever they needed to be said to say. And given what I would describe as the procedural shenanigans since, we would say it's very clearly desirable. Otherwise, we are going to end up in a position where everything, even when we win, if we do, everything possible will be done to frustrate that outcome. What I do say is that in his oral and written submissions, my learned friend never really provides an answer to the fundamental point, which is that if we're going to have an action on these agreements against the first two defendants, it must be desirable to have the third defendant joined into that so they can say what they want and be bound by it. The main argument you have, and the thing that we spent the most time on this morning, is that you never get to consider that for procedural reasons. I do say that would be surprising if it was right. It's not right, and I'll come back to that. But let's just look at how the argument is developed in the submissions from my learned friend, picking up the points that he made in oral argument. So, as I say, he starts at paragraph 20, and his arguments are mixed between, sorry, page 20, paragraph 81, and the argument is blended. For and non-conveniens and desirability are joined together. Now, paragraph 82 is the first substantive set of points, and we do say it is quite difficult to extract from the arguments that are presented exactly what the central point is that is being made. Some of the arguments that are being made are just obviously wrong, we would say. So, for example, paragraph 82A, my learned friend says that the basis of the claimant's substantive claim against, I think, D1 is purely contractual, and that is not right. The main claim that we advance is a statutory claim under the DCC regulations. The application of those regulations is not, it's contractual in a sense, but in the sense that always applies to companies, in that the shareholders have to come together with the company in effectively the company contract. But the application of regulations to that company is statutory. But in any event, as we understand it, the really central point being made is that the third defendant is saying, well, I am not a party to the agreement which gives this court jurisdiction. That seems to be what is being said in substance. In paragraphs 83 and 84, for example, seem to be saying that, albeit they put it in slightly different ways. So, for example, in paragraph 83, my learned friend says, well, third defendant isn't the director, it's got no direct beneficial interest in the second defendant, but then says, well, the issues of whether the first defendant breached his duties have no bearing on the validity of the agreements. So he says that in paragraph 84. And that's quite difficult to understand. We don't really understand the terms of those paragraphs, if we're honest, given the terms of the regulations, because the regulations expressly permit this court to set aside a transaction in those circumstances where they're entered into in relevant breach of duty, if I can put it like that. But in any event, what's that got to do with whether or not this court has jurisdiction over this? That would be some sort of merits response. As I say, the central point seems to be the third defendant didn't agree to this court's jurisdiction. But again, that is not relevant, because if the third defendant had agreed to this court's jurisdiction, there would be no need to use the Nest gateway. It is also, we say as a submission, a bit rich, given that the third defendant is owned and controlled, by the first defendant who did agree to the DIFC court's jurisdiction. So on the technical front, if I can put it like that, it doesn't change the position, but also on the merits front, if I can put it like that, it doesn't change the position either, because you've got the same human being who has agreed. My learned friend then goes on to make a sort of second series of points, and he again referred to this in his oral argument, which is that he says, well, the claimants, this is at paragraph 86 and onwards, he says the claimants have no standing. And why is that relevant for today? Well, he says the claimants have no real prospects of success in their claim against the third defendant. That is a merits point. It's asserted without an awful lot of argument. It doesn't feature actually in the defence and counterclaim, and there is no application for some immediate judgment or to strike out the particulars of claim on this basis that's been advanced by the first defendant. The first defendant's just pleaded in response to it. But the issue of standing is a bit odd, frankly, because the regulations themselves give the shareholders standing. Specifically Article 79.6. I'll just remind Your Honour of that. It's at page 1676 of the bundle. 1676. Paragraph, and it's article regulation 79.6. It's not said, as I understand it, that this doesn't apply. And what that regulation says is that where a director fails to declare an interest under this regulation 79, the company or a member of the company or the authority may apply to the court for an order setting aside the transaction concerned and directing that the director account, and so forth. So my learned friend relies on decisions from England and Wales, and also from a decision in the DIFC, which is derived from the law of the rule in Foss and Harbottle, which obviously makes that distinction between who can and who can't make claims on behalf of the company. And there are various statutory exceptions to the rule in Foss and Harbottle, and those differ from jurisdiction to jurisdiction. In England and Wales, for example, the primary one is that one has to make a derivative claim. One has to come to the court to ask for the permission to do that. It's controlled, but it is a statutory exception to the rule in Foss and Harbottle. And in fact, DIFC law itself has other statutory exceptions to that, which permit shareholders in appropriate circumstances that gives them standing to make claims and applications of certain types. Here we are dealing with a company governed by these regulations, and those regulations confer the standing to make certain types of application. My learned friend, in his skeleton argument, if you actually look at 86F of his skeleton argument on page 22, so he accepts that the claimants have standing to seek an account from the first defendant pursuant to their agreement as members. So he says, whilst under the DCC regulations, the claimants have standing to seek an account from D1. But as we've just seen, the right for them to claim an account arises under 79.6 as the second half of the sentence. So for an order setting aside the transaction concerned and directing the director account. So there is a logic. The
account is conditional upon setting aside the agreement.
It is. But the point I'm making here is that this regulation confers onto the shareholders, the members, the right to do two things. One is applied to the court to set aside. The other is for the account. My learned friend accepts that I have standing, or my clients have standing, to make the latter. But my point is that they both come from the same source. Yeah. So there's a logical incoherence in his position in relation to this. But ultimately, all of this is based effectively on the merits of the claim. So these are points that the first defendant or the third defendant can take in the proceedings. They shouldn't precede the question of whether or not the court has jurisdiction. And we say the whole point of these provisions is to protect shareholders in circumstances like these, where as we would describe him, the first defendant acting as a rogue defendant who is a rogue director who's in control of the company. Well, I may be right about that. I may be wrong about that, and I'm not asking Your Honour to decide. That's the merits, but that is clearly what these sorts of claims, these sorts of provisions are intended to facilitate, is claims very much of this sort. Now, my learned friend says, well, this is all terribly exorbitant that the court would exercise jurisdiction over the third defendant in relation to this. The short answer to that is it's not the issue. The issue is whether or not the court has jurisdiction, and that is answered by Rule 20.7, is it desirable to add the third defendant? The longer answer is actually, well, is it that surprising? If you contract with a company that is registered in the DMCC, you can be taken to know that these rules apply, and in certain circumstances, the court of the company, whatever that may be agreed to be, will have the authority to make these sorts of in rem decisions, and that is true all over the world in relation to all types of company. There will be insolvency regimes, for example, which have clawback provisions in certain circumstances. Very unusual to find a jurisdiction which does not have things like that. So if I go and contract with a company from wherever it may be, I know full well I may end up in the courts of that company one day, looking at the question of whether or not transactions I entered into with the company are at an undervalue or otherwise voidable or indeed void. That's just the risk that I take, and particularly the risk that I take if I know I'm the director who has established another company, and I am causing this company to contract with that company, and I was the person who actually I agreed directly to the DIFC courts myself. So we say this argument that there is no real prospect of success and that is something you should take into account is a lot. It's also, by the way, inconsistent with the counterclaim, we would say. So if you look at page 46 of the bundle, for example, I hope you will find the defence and counterclaim in paragraph 86 in the counterclaim asserts a similar sort of claim against my clients, relying on different contracts, not contracts that my clients caused the company to enter into, clients that because he was in control of this, and so we say it's all misconceived. But putting that aside, he's making claims in his capacity as a member of the second defendant, seeking orders for accounts, for profit, and so forth. But ultimately, these merits points are not for today. And the DIFC court's been very clear about that in the way that it's dealt with jurisdiction arguments. In cases like Protivity, you will find. I had the misfortune of arguing that case and arguing that there was, as there is in England, a real prospect of success threshold when considering jurisdiction, and the court unequivocally rejected that position. The third point that is raised in the skeleton argument and was again raised today, you'll see it at 89 of the skeleton on page 23, is that it is pointed out that the claimants assert no proprietary interest in the intellectual property. Of course, that is correct. But what I'm not sure that it was pressed today, but it certainly is forms part of the skeleton. It is said that the DIFC court has no jurisdiction to determine the ownership of those intellectual property rights. But that, of course, is wrong to the extent that it arises as an issue in this claim. The court has jurisdiction over claims and therefore has jurisdiction to determine all of the issues that arise in the claim. So the way that the ownership issue arises in this claim is that my client claims orders setting aside the agreement which purports to assign from the second to the third defendant the IP rights. And in response to that, the third defendant wants to say, well, I already own those rights, and so there's no point in setting aside an agreement which purports to confer those rights onto me again. And so what my learned friend is saying is, well, I can make that argument, I already own the rights, and then that disqualifies this court from hearing the claim, because I've raised an issue which is not judiciable in this court. It is a remarkable argument intended just to block. It's intended to get in the way of the proper resolution of these disputes. In this context, my learned friend repeats the complaint that my clients have asserted in another jurisdiction, that the software concerned is owned by an Egyptian company, which we've all referred to as Health Insights Egypt. And my learned friend says, well, you have to ask the question, why would they be saying to Egyptian courts that Health Insights Egypt owns these rights? I've already explained why that was said. It's because that's what the first defendant told us. And then, since that time, opposite statements have been made in various documents to the effect that those rights were owned by the second defendant. And Your Honour may recall that there are certificates that were procured by Mr. Shehata, which said that in terms. So you'll see them, for example, at page 858 of the bundle. There are 3 of them. So he has gone to this Interroco organisation and asserted that the second defendant owns these rights. And then, of course, in the assignment agreement itself, you can see at page 577 of the bundle, there is a warranty in there that the second defendant owns those rights. Those are documents signed by Mr. Shehata. One asks the question, why on earth would he be making agreements between 2 companies he's in control of, purporting to assign rights, which he says the recipient already owned? And there are only 2 answers to that, and neither of them is terribly good. Neither of them makes Mr. Shehata look very good. I mean, either those are sham documents that he has procured, or in fact, the second defendant did own those rights, and he is not telling the truth. There is suggestion in this context as well at paragraph 90 of the skeleton argument, and repeated again today, that the inclusion of a third defendant will complicate the case. But actually what he says is that the attempts to expand the proceedings beyond the original dispute will complicate the case. And again, that makes the central error, which is to forget that if one removes the third defendant, we're still having all the same issues determined by this court as came before. Adding the third defendant does not add complexity, particularly as my learned friend has made the submission that the third defendant has nothing additional to say about any of this. It is right that the claim has developed to some extent, and I'll come back to this as to whether this somehow blocks you from accepting jurisdiction in respect of the third defendant. The primary complaint in this case was twofold. Firstly, there was a dispute about whether or not the board resolution was effective. And you'll recall that was quite a narrow dispute, and that's why we brought it to the court in a relatively narrow way, and Your Honour resolved that. And it was anticipated that once Your Honour had resolved that resolution was effective, then that's the end of that, and we can move forward. But unfortunately, that has not been the position. So we have had to add a claim for an injunction against the first defendant, requiring him to do what he's told to do. Again, that's not relevant for today, though, because that's a claim against the first defendant who makes no jurisdiction application, and this is the third defendant's. Because of the way in which the case was presented at the last hearing, the case has developed in another way. And the reason for that is because the second part of the claim was obviously the claim to set aside what's being referred to as the assignment agreement, and for an account in relation to that. And the defendant's response at the last hearing was to produce that document that's been referred to as the purchase order. And that's to support the case that's being advanced, that the third defendant has always owned this software. And so what is said is that that purchase order is a contract by which the third defendant engaged the second defendant to develop this software in a way that conferred proprietary rights over the software onto the third defendant. So the result of that, and I think I mentioned it at the hearing last time, was, well, that looks like another contract that we're going to have to look at carefully and see whether it needs to be set aside, and it will need to be set aside for precisely the same grounds as the assignment agreement, if in fact it is a real agreement at all, and on that we reserve our position. So it is right that the case has developed to that extent, but it is all a feature, a part of the main claim, which is that the assignment agreement needs to be set aside, and there's purpose to doing it. Again, that is all in the proceedings brought against the first and second defendants, and that will go ahead come what may. And so the only question is it desirable that the third defendant be a party to that? And of course, the answer is the same as in relation to the claims that arise in respect of the assignment agreement. Adding the third defendant to those claims does not introduce more issues. It just, because all of those issues are already in play. Just continuing on through the skeleton, there's a fourth point at paragraph 91 of the skeleton on page 24, which says, well, there's no material connection with the DIFC. I mean, this is really just the same point again, that there's no other jurisdictional gateway. The connection, or the main connection, is that there's going to be a trial on these issues in the DIFC come what may. Now, there are other cases that have looked at these sorts of issues, often in slightly different contexts, and quite often what happens is you have a claim which raises the same issues against two defendants, one of whom has a jurisdiction agreement and one of whom does not. And this court has been consistent in effectively overriding jurisdiction agreements in that case. So we've produced an example, which is the Orion case, and I might just show you a couple of passages from that, if I may. I'll just to introduce it, that was a case in which there were 3 companies in liquidation. Two were in the DIFC, 1 not. And so the companies were bringing claims against, firstly, their former directors, and secondly, against a Swiss bank. And the claims against the Swiss bank related to pledges, which had been granted in favour of the bank, and all of them contained Zurich jurisdiction agreements. If we go to page 1793, you can see the basic facts set out in paragraphs 1 and 2, and then you can see the agreement at the bottom of paragraph 2 there. So there was a Zurich jurisdiction agreement. And so the court looked at the jurisdiction arguments in relation to this, and you'll see on page 1795, paragraphs 12 to 14, how the court dealt with it. I'm not, you'll be relieved to hear, going to read all of that out. But essentially what was being said was, firstly, the court has jurisdiction because 2 of the claimants are DIFC participants. And then applied the reasoning from a former case in Karafi to say there is likely to be a trial in the DIFC courts to determine the case against D1 and D2 concerning matters of DIFC law. And so there would be a risk of inconsistent findings and a real likelihood of duplication if you were also going to have claims on related matters in Zurich. And so what the court found, you can see it at the end of paragraph 13, if the jurisdiction application were to succeed, procedural dislocation would be sought, would be caused. And dismisses forum non-conveniens on effectively the same basis. And so in that case, the court went so far as to say, well, look, we've actually got a countervailing jurisdiction agreement here, but because we have a claim that's going to happen in the DIFC anyway, we're not going to allow you to enforce that jurisdiction agreement. So we would say, even more so where there is no jurisdiction agreement. I'll deal with the arbitration agreement separately. Just looking at the question, is it desirable? The answer in Orion was it's so desirable that we're not going to enforce a jurisdiction agreement. And so we say that supports our position in relation to this. We then get on to the convenient forum submissions at paragraph 92 of my learned friend's skeleton argument. And as I say, these are presented as forum non-conveniens, but also as questions of desirability, and you've got a list of them. You will see going through it at H, and I think we heard this today as well, my learned friend says that Malaysia is the natural forum for this claim against the third defendant. I would suggest that is a pretty remarkable submission to make. The submission ignores the fact that we're going to litigate all these issues in the DIFC in the first place. And as I say, the proposition appears to be that we should have one trial against D1 and D2 in the DIFC and another separate trial on the same issues against the third defendant in Malaysia. And we do say there are other good reasons why this is the right call anyway. It's slightly unusual because normally the courts which would resolve these sorts of internal management questions would be the courts of the jurisdiction where the company was registered. As I say, it's not unusual with DCC companies and the facility is there to select another court, and this court has been selected. So if one takes that as the starting point, we would say the natural place for claims about the internal management of a company are the court which is either by default or by selection, the one which is the place where that company is registered, and the court which has supervision of those issues. And we rely on a case called Sesklevenska in relation to that, which was Mr. Sumption QC as he was back then, but Lord Sumption as he became, where he makes that point. But I don't think I need to labour it. It's not Malaysia, is the point that we would make. We'll look at that, and we can look at that if necessary on foreign non-conveniens. But we would say the starting point then is that it's desirable to have the third defendant joined. We would say nothing that the third defendant has said even begins to suggest otherwise on these discrete points. So that really ought to be the heart of the question, desirability. What about all these procedural complaints? So the first complaint that is made is there was no application to join the third defendant. And that morphed slightly into there was no application to join under Rule 20.7. But the issue ought to be, well, we say it's wrong, and secondly, it's irrelevant. Why is it irrelevant? And I'll start there. It's because we've got a court order. And the third defendant has not applied to set it aside. I'll remind you of the order. It's at page 538 of the bundle. That's the order Your Honour made on the 4th of March. And then on page 539, paragraph 2, Health Insights is joined as third defendant. So we say there is a short answer to all of this. It has already happened. Either the third defendant has to appeal that order, or alternatively, he has to find some way to make an application to set it aside, possibly under 20.8. But arguing that there was no proper application or there was some problem with the way that order was made is completely irrelevant, even if there was no application at all. Even if Your Honour just simply made that order of your own motion, there would still be an order. If the order was made of Your Honour's own motion, had been, the answer would be in Rule 4.9. Which says you can do that, you can make that order of your own motion. And 4.10 says the court may give a person likely to be affected by the order an opportunity to make representations, doesn't have to. But if you don't, then the court can make the order under 4.12. The court may make an order of its own initiative without hearing the parties or giving them an opportunity to make representations. But in those circumstances, you're into Rule 4.13, which says, well, then there is a right on that party to make an application to set aside the order. But the deadline for that is 7 days. And of course, this was an application, sorry, an order that was made on the 4th of March. So we're 7 months later. We do say, though, that the submission is wrong. There was an application to join the third defendant, page 519. Sorry, I've got different page numbers, so it's difficult. 519, bottom right. And I think I say, so the first application I would make, does Your Honour have that?
Yes.
Would be for an order to join the Malaysian entity as a defendant to the proceedings. Now, that was all done in the context of Your Honour having already indicated that you considered that it was necessary for that to happen. Now, it's right that we didn't go to 20.7 in terms, and my learned friend says, well, it was all done wrongly. But I don't accept that that is correct. But even if it is correct, the issue is not then has the party been joined, because it has. The issue would be, well, was that correctly made? Was that order correctly made? And can it be set aside? And you would need an application within the appropriate timescale to do that. You'll see how Your Honour dealt with this. If you go down to page 524, Your Honour I would summarize it like this. So if Your Honour just reads that, starting from under where Your Honour is speaking, yes, all right. You say, I'll come back to you, Mr. Shehata. What happens is you effectively agree with the position that they ought to be joined, and you ask Mr. Shehata, what do you say about that? And we would say that it appeared, and certainly was understood at the time, that Mr. Shehata was agreeing.
Yes.
So we do say that we made an application to join. You gave Mr. Shehata an opportunity to respond to that application, and he consented to it, and that he later confirmed that he was the managing director of the third defendant. You see that at page 525 and 526. Now, my learned friend makes a series of technical points about this. He says, well, if you make an application, you have to serve an application notice. Actually, Rule 23.3 says the court needn't insist on an application. The court can dispense with an application notice, and we can get wrapped up in the precise technicalities of the rules here. But Your Honour has plenty of experience of dealing with cases and comes across applications that are made on an ad hoc basis all the time. And indeed, my learned friend has made them in these proceedings. So, for example, Mr. Shehata at the first hearing made an application for an adjournment. He didn't serve an application notice, and it would be absurd for me to take the point. My learned friend attended at the second hearing. And I'll come back to this point, but in principle, without his client, the third defendant, having served an acknowledgement of service and made an application, or should have done, to be able to be heard at that hearing, and went on to make submissions on behalf of the third defendant. My learned friend's clients served evidence extremely late in the day and made an application without serving an application notice for permission to rely on that very late evidence. All of that was done without application notices. And it is not right to say that somehow there's some special rule for Part 20 applications, because they just require applications to be made in accordance with Part 23. In an appropriate case, this court will say, fine, go ahead and make your application. All kinds of applications are made in that way. But the fundamental point is that my learned friend says his client's been robbed of the right to contest jurisdiction, if that is the determining factor. And that's just fundamentally wrong, we say. It hasn't. First, it could have resisted the order at the hearing. It could have appealed the order after the hearing. If I'm wrong about that, it could have applied to set aside that order either within 7 days, if it's an order, or made an application under Rule 20.8, but would probably require a change of circumstances. Hasn't done any of those things. Even though, as early as lawyers were involved, the defendant intimated that it was going to do something along these sorts of lines. It would contest the joinder of the third defendant. It said that. You can see that on page 12 in the acknowledgement of service. But if all of that is wrong, then now is the opportunity to challenge the joinder. Now is the time to tell you these are the compelling reasons why it is not desirable to join the third defendant. And I've already given you my answers to the points that are made in relation to that. So we say that the procedure for joinder is not a reason to refuse jurisdiction. It's a reason to find, in fact, that the preconditions for jurisdiction have already been satisfied. I do not accept that there is anything in Nest Investments which tells you otherwise. My learned friend repeatedly said Nest Investments, Court of Appeal Authority, tells you, and it's hard to know exactly what his submission was, but I think he was saying, according to Nest Investments, there has to be a post-issue application for 20.7 for this court to find jurisdiction. And he referred you to commentary in the second edition, which is in the bundle, but the commentary itself relies actually only on paragraph 18 of Nest Investments, which you find at page 1779.
I won't ask who was the author of this commentary.
Wasn't me. I'm going to answer anyway. But the point there is that paragraph 18 is reciting the decision of the judge, where he says, so once, sorry, it's not page 1779, is it? It's going to be different for you. My apologies. Hopefully someone will tell me what page it is. But I'm looking at paragraph 18 of Nest Investments.
The Court of Appeal judgment or the first instance?
The Court of Appeal decision.
The page number I have for that is 1781.
1781. Thank you very much. The difference between my bundle and the online bundle varies from 2 to 7 at different places, plus or minus. 1781. Thank you. So if we go to 1781, paragraph 18. Here, if you scroll back a little bit, the court is dealing with, you can see it from the page before, the judgment of Justice Roger Giles. And so it goes through the decision that's been made. And you'll see the judge held that reliance upon the rule at that time was misplaced, as it was ultimately accepted by the claimants. The possibility of an order under the rule did not mean that jurisdiction existed at the time in circumstances where Mr. El-Fadil had already been named and so forth. So my learned friend relies on the second sentence, which is clearly also just reciting the decision of the judge. It's not a finding that, in effect, a hypothetical, that the court could take jurisdiction on the basis of a hypothetical application under Rule 20.7. And then you'll see how Sir Jeremy Cook deals with it. Discussion and analysis starts, I'm going to hazard a guess, at 1783, paragraph 38 and following. And so, for example, at 1785, paragraph 47, Sir Jeremy says, when RDC 20.7 provides that the court may order a person to be added as a party in the circumstances there set out, the question is whether that is properly read as giving the court a power to assume jurisdiction over a party where the criteria of that rule is met. Not where an application is made, but where the criteria of that rule is met. And so, again, if you go down to 1787, paragraph 59, in all the circumstances and for the above reasons, we consider that the court does have jurisdiction because Rule 20.7 is a DIFC regulation which confers jurisdiction.
Sorry, what paragraph are you on now?
59, apologies.
Thank you. Yes.
So 59, just picking it up at the end of the first line, RDC 20.7 is a DIFC regulation which confers jurisdiction upon the court, which it can exercise as a matter of discretion if the criteria set out in the rule are met. And fundamentally, that first instance decision from Justice Roger Giles was overturned. The court found it did have jurisdiction. And so, although the court doesn't say, and by the way, we disagree that you need to make that application, that must be implicit in the outcome. What about these complaints about the amendments to the statement of case? This is the subject of a lengthy discussion in my learned friend Skeleton, paragraph 36 and onwards. So the complaint is made that the claim has expanded, firstly to include the injunction claim against the first defendant, secondly to include claims relating to the purchase order, to declare it void or set it aside and for an account in relation to that. I think my learned friend accepts that the first part of that is irrelevant because that's a claim against the first defendant. And I've explained why the need for that became apparent after Your Honour's declaration and the first defendant's subsequent refusal to act in accordance with it. I mean, ultimately, in relation to that part of it, the application or the claim for an injunction against the first defendant, the hope and expectation was firstly that the first defendant, having had the issue that he'd raised, the validity of that resolution resolved, would act like a proper director and comply with validly made board directions, but he's not doing that. The expectation was also that the Dubai Development Authority, which is the regulatory authority for companies in the DCC, would also look at Your Honour's order and say, well, now we understand that that resolution is effective, we will give effect to it, because previously they had refused to do so because they were also taking the position that all of the directors needed to sign off on the board resolution. Now, Your Honour's decision on that has not been the subject of any subsequent appeal or challenge. It was obviously and plainly right. It's extremely disappointing that the DDA is not helping us in the way that we're doing. And the result of that is here we are a year after starting these proceedings, and the company continues to be under the control of someone who ought not to have control over it, and ought not to have done so since May of last year. But that's why we've had to develop that claim to add the injunction claim against the first defendant. And we say it's obviously appropriate that that claim be tried in the same proceedings. Now, the first defendant has answered that claim. He's not taken the point that it expands the claim beyond what was previously pleaded in the claim form. If there really is resistance to that, and the court is really interested in this point, we can make an application to amend the claim form. That is what would have to happen. We would not, I would not encourage Your Honour to give credence to this, because that would be a formulaic application. And as I say, the first defendant has already pleaded to that claim. I mean, ultimately, it's the kind of application, if we had to make it, and it wasn't accepted, where this court would make indemnity costs orders in relation to it.
Well, I'm trying to remember where a statement of claim goes beyond, well, of course, I'm used to think back in the days of writs, where a statement of claim goes beyond an endorsement and a defendant pleads to it, is waived any objection to it, I would have thought.
Well, and all of those arguments could be raised by the first defendant in the proper way, and we can have an argument about whether or not there's a waiver, and whether or not, if there wasn't a waiver, whether there would have to be an amendment to the claim form, and all kinds of other things could be raised. But actually, they're not before you today because the first defendant's. So I think there would be plenty of answers if the first defendant really dug in his heels and said, you know, you can't bring this claim against me because, well, for what reason? There isn't a good reason. And you know, the aim of these rules, even though they are rather long, is to try to avoid those sorts of the old school writ style procedural expense that was associated with having those sorts of arguments. And we do say they achieve that. It's just a question of how you interpret the rules, but there you are. And now the other part of the new pleadings, if I can point it like that, as I mentioned, arose out of really what was said in the last hearing rather than what was presented in the evidence, even though the evidence was out there, because the evidence came in, as you may not recall this, but a very large amount of documentation with a covering witness statement was served in the national holiday shortly before the hearing. And my learned friend showed you some of it and made submissions about some of it. And so it was really in that course of those submissions that we discovered this case, that it was said, oh, well, this was always belonged to HI Malaysia because of, look, here's this purchase order, which was buried in the annex. And what the third defendant was saying was that it had hired the second defendant to prepare or produce this software, and that's why it owned it, and they produced this purchase order. And as I mentioned previously, I think I said at the hearing, and you probably find it somewhere in the transcript if my memory isn't terrible, which it probably is, but you know, that was another contract that we would need to approach the court to ask the court to set aside or declare that it's void. And so the timing, the development of the case is entirely explicable. It arose because that's when we were told about it. Now, again, the first defendant has pleaded to it. The second defendant hasn't put any defense. That's fine. But the basis for the court's jurisdiction over the third defendant in respect of that particular contract is exactly the same as the basis for the court's jurisdiction in relation to the assignment agreement. All of the same points arise. Now, in his skeleton argument, paragraph 39 we're looking at, my learned friend says that these claims go, as he describes it, far beyond the jurisdiction clause in the articles. So he says they go far beyond the bounds of the jurisdiction clause in the articles and plead issues that have nothing to do with the claimants and so forth. We say that is wrong and irrelevant. It is wrong because the claims clearly are within the terms of the DIFC jurisdiction agreement. If you're worried about this point, I'll show you the jurisdiction agreement. It's at page 858. The top right of the page, 858, clause 28.2. The DIFC courts have exclusive jurisdiction to settle any dispute arising from or connected with these articles, or the consequences of its nullity and so forth. So clearly what we're saying is that this was entered into in breach of duty. The articles incorporate the regs. It's obviously related to the articles. So it's wrong, but it's also fundamentally irrelevant because the question of the scope of the jurisdiction agreement would be a point for the first and second defendants to make, and they don't take a jurisdiction objection. So the court has jurisdiction over that claim against the first and second defendants. The only question becomes, is it desirable for the third defendant to be joined to that claim? So this is being presented as some sort of exorbitant jurisdiction that the court is being invited to exercise, and that is not right at all. As I say, if you contract with a company, you may be drawn into disputes in its home jurisdiction, and where the person in control of both sides of that contract is a member of the company, they can hardly complain about that and say it's all terribly surprising and exorbitant. So that fundamentally is what we say about the points that my friend raises. But fundamentally what you should be concerned with is whether or not this is desirable for the third defendant to be a party. Plainly is. If Your Honour finds that, then all of these other extraneous points rather fall away, we say. That said, we do find it quite surprising that we are facing a jurisdiction application from the third defendant at all. And I say that because of the way in which the third defendant has participated in these proceedings prior to the jurisdiction application. I've alluded to it previously, but Your Honour may recall that there was an issue about whether or not the third defendant should be entitled to make submissions at the last hearing. Because
I don't remember it, I'm afraid.
I'll show it to you then, if I may. If Your Honour goes to page 297. Well, let's start with the acknowledgement of service itself, actually. The original one, which you'll find on page, I think it's 11. And this is dated 19th of March, so shortly before the previous hearing, just after, it's in between the two hearings. And so the point about this is that where it says defendant's name, you've got only two names entered of the first and second defendants. So when it came to the hearing before Your Honour, which at that stage was on the Part 8 basis, there was an issue about whether or not the third defendant should be entitled to say anything. And the question arose in relation to that. That's when we go to page 297. And if I can ask you, please, just to read the final paragraph of that page.
Well, I can't yet. I suspect it's going to say, yes, I do have it.
Thank you. So these are submissions that I made, and I just raised this point, not to take a technical point, but to point out that there might be a tactic going on here.
Yes, I've got as far as Mr. Doherty's response on page.
So Mr. Doherty on page 298, in the middle of the page, says, yes, I'm instructed by all three defendants. And then over the page, at page 3, what will be 299 and on to the top of 300, the response came back, I'm instructed by all three defendants. The attempt was made to file the acknowledgement of service on behalf of all three of them, but there was just a technical problem with it. It's not tactical, it's just a glitch, was the answer. So we, having raised it, having received that response, understood that what was happening was that the third defendant's advocate was adopting for the third defendant the acknowledgement of service, which had technically on the system only been filed or registered as being filed on behalf of the first two defendants. And the reason I raised it in the first place at that hearing was to avoid the third defendant being able to have its cake and eat it by both making submissions on the case at that hearing and then subsequently coming back later and saying, oh, no, I don't accept jurisdiction. And you'll see from the acknowledgement of service, if we go back up to page 11, you'll see in the middle of that page, the defendant, as defined there, intends to defend all of this claim.
Yes.
On the basis of alleged factual disputes. They disputed the Part 8 procedure. They did identify on what would be page 12, I think, that they would make they would dispute the addition of the third defendant.
Yes.
To these procedures, but they of course never made that application. And this is on the 19th of March. So my learned friend tells you, well, we put in an acknowledgement of service, and there was a direction subsequently, not made in the light of any submissions by any of the parties, but there was a direction subsequently that they can put in an acknowledgement of service. We did not understand that direction to be precluding us from making the point that they have already put in an acknowledgement of service. Technically, it went in by D1 and D2, but it was adopted subsequently by D3, or confirmation was made that it was also D3's acknowledgement of service. So if that was right, then the time to make an application disputing jurisdiction expired on the 2nd of April. And of course, the jurisdiction application didn't come until the 25th of July. So nearly 4 months out of time, we would say. Not only that, and my learned friend's got points about submission not creating jurisdiction, and I'll come back to that in a moment. But my learned friend did make submissions on the substance of the case at that hearing. Not only dealing with the claims that were then pleaded, but also positively asserting a case on the basis of the purchase order itself. Now, I'm not going to take you through all of those. I might show you just one or two examples. But there's a list of them on page 7 of our skeleton argument. We identify some of them. And my learned friend seeks to recharacterize them, we say, today, because he says he was only ever talking about procedure. It was never any kind of engagement with the merits. We find that to be a surprising submission. What I will show you is what that hearing was about. I'll just remind you on what that hearing was about. So on page 590, your reasons for, sorry, I think it's 597. I do apologize. Where you set out the issues, paragraph. I do apologize. I'm afraid my the drilling has started up outside as well. Paragraph 48 of Your Honour's reasons. 48. Bear with me. I'm going to just see if I can stop this drilling.
Yes, I have.
I do apologise. I'm just trying to get them to stop drilling. They promised they would. In these days of remote hearings, we normally get some notice, but we haven't, I'm afraid, today. So we'll see if my clerks can fix that. We'll see. Last time over the lovely sounds of a pneumatic drill, I could actually hear one of my senior clerks yelling out the window. So let's hope that is repeated.
Well, it might be my poor hearing. I've not heard the drilling yet, I have to tell you.
Okay, maybe filtered out, in which case it's only a problem for me. So the point I was just going to make was this. Firstly, Your Honour, Your Honour identified in the issues, paragraph 48, the issues before you on that day were not just should the claims proceed under the Part 8 procedure. They were also paragraphs 3 and 4. Should the court make any orders sought by the claimants in their claim form? Should the court make any other or different order? There was no jurisdiction application that had been made at this point, and the defendants were therefore engaging not only on the question of procedure, should this be Part 8 or Part 7, not at all on the question of jurisdiction, but also on the substance of the claims. And just to make that good, just make another point in relation to the way that this was approached in the evidence. I think it's page 669 and paragraph 34. I'm showing you of Mr. Shehata's first statement. This is the first defendant's first statement. And he says, paragraph 34, for the reasons that should be apparent above, I dispute the basis of this claim entirely and intend to mount a full defence against it. For that reason, I will ask the court makes case management directions that afford the defendants a reasonable opportunity to set out that defence. So the suggestion that you were not, that the submissions being made and the evidence being submitted was not intended to engage on the merits of the dispute is difficult, we say, to understand or follow. My learned friend told the court that the third defendant had always owned the software and said, well, that is a reason why you shouldn't make substantively an order today setting aside the assignment agreement. Why? Because the exercise of your discretion in doing so will be affected by the utility of the agreement and various other factors. So it was a submission that was being made on the merits. Now, on all of that, we say, my own friend, on behalf of his clients, submitted to the jurisdiction of this court Now, I'll come on to the points about whether that makes difference on the legal analysis. You said it does. He resisted judgment, though, on the basis of a defence that he asserted for his clients. Now, in part, that failed on the declaration. In part, it succeeded. What he can't do is say, well, on the bits that I succeeded on, I'm going to take a step back now and dispute jurisdiction. Now, my learned friend makes this point that you cannot create jurisdiction by submitting to the DIFC courts. And that is correct. So the DIFC courts is a statutory court. You have to find the jurisdiction somewhere. It's only the way he characterizes it, though, the way he deploys it is not correct, though. Submission can't create jurisdiction which doesn't otherwise exist. But you can submit in the sense of waiving personal objections to jurisdiction. That's the Hart and Damak case, which has subsequently been effectively approved in subsequent cases. So it's at page 1701 of the bundle is the relevant part of that. And I'm not going to show you a lot of it, given the time, but essentially the judge endorses a passage from the then edition of Dicey and Morris, which says the principle of submission can give the court jurisdiction only to the extent of removing objections thereto which are purely personal to the parties submitting. For example, service and so forth. Not limited to service. But what that does mean, we say, is that where the issue at play is one of discretion or evaluation for non-conveniens or joinder under Part 20, Rule 20.7, it is entirely open to this court to say that the third defendant has already responded to this claim, has already waived the right to take those sorts of points. And it doesn't mean, just slightly separately, it doesn't mean that this court has to entertain jurisdiction applications whenever they are made. So the fact that that jurisdiction can't be created in this court doesn't mean, for example, that halfway through a trial, if I say, oh, by the way, this trial's going badly, I want to make a jurisdiction objection, it doesn't mean this court has to entertain that objection. It's still in control of its own processes in how it hears and determines those sorts of applications. So waiver does, we say, rule out the sorts of arguments that are being made today, and it does rule out, we say, the application itself. Insofar as there isn't really anything different that's raised on forum non-conveniens. There's not much between us on the test. It's the English test, not the Australian test or the American test. That's the Prativity decision. Forum non-conveniens arguments can definitely be waived, because they're about exercising jurisdiction, not about creating it. But all of the same points arise about waiver, and ultimately the reasons why it's desirable to have the third defendant here are the same reasons as why it's not clearly and distinctly more appropriate to hear the claim in Malaysia. Underlying it all is the fact that there's going to be a claim on these issues here between the same natural persons involving the same evidence. So unless you want me to say anything more about forum non specifically, I was going to leave that there and move on to the arbitration agreement, if I may.
Yes,
all right.
Please.
I mean, we find this application somewhat baffling because my clients are not party to an arbitration agreement, even if you accept that it is a valid arbitration agreement, which we do not. Even if you accept that, it can't be enforced against my clients and used to prevent. Now, my learned friend tries to find various different ways around this, but none of them actually make any sense, we say. It is, or it should be obvious to any arbitration practitioner that only the parties to the arbitration agreement are bound by the terms of the arbitration agreement, and that is all that the legislation responds to. So the arbitration agreement is in the assignment. It's not, by the way, in the purchase order, so this couldn't affect the claims in relation to the purchase order one way or another, even if my learned friend gets off the ground on it. But there are no such provisions in the purchase order. But could only give rise if the second defendant was to bring a claim against the third defendant. It's only in those circumstances that there could be a response. Now, we've referred to a case called...
in that circumstance, I mean, it comes back to what the matter is and so on within the Section 13.
Yeah, but in that circumstance,
In that
I think
circumstance.
what my learned friend says is, if you go to Article 13 of the Arbitration Law and you turn it up at page, I think it's 1522, I think 1531.
I've got a hard copy.
Oh, that makes my life much easier. Thank you. So he says, look at Article 13.1.
Yeah.
Ask yourself the question: is this an action in a matter which is subject of an arbitration agreement?
Yes.
He says, well, that this claim fits the description, but what that does is ignores the fact that an arbitration agreement is not an in rem agreement. So an arbitration agreement covers claims, and only claims by parties. So unless this claim is a claim by a party to the agreement, it's not a matter which is the subject of an arbitration agreement.
Quite.
It's very straightforward. Now, I won't labour the point, but what my learned friend does to try to sidestep this is he says, well, he wants a case management stay. So it's not a stay under Article 13, but he says, well, there's a case called International Electromechanical Services where the court granted a case management stay because there was a related dispute by the claimant, which was governed by an arbitration agreement. Number of short points there. Firstly, there is no application for a case management stay in these proceedings. You're not asked the question, is there an arbitration application at all? Not obviously on the face of the application notice, but it is referred to in the witness statement. So the application notice is at page 114, I believe. I'm afraid this may be where my
Yes, I have the application.
Yeah, so you'll see it's a jurisdiction application. And bottom left, so 114, bottom left, at the bottom of that page, the court does not have jurisdiction to hear the claim. But that is not actually an application under Article 13 of the Arbitration Law. That said, we did not take the point. Why not? Because the application was supported by a witness statement, the second statement of Mr. Shehata.
Nice.
And if you see at page 116, 136 perhaps. Yeah, I think it's 136, paragraphs 48 to 51 is where he deals with the arbitration side of things, and it is squarely on the basis of Article, well, misnamed 12.1, but oh no, he does refer to Article 12.1. Sorry, and then he makes it. He refers to Article 13 of the Arbitration Law, and then says paragraph 51. Based on the provisions of the Arbitration Law, the court has no jurisdiction to adjudicate. Now, we don't take technical point that is somehow not an application under Article 13.
No.
But what it isn't is an application advanced on case management grounds for a stay. And one can see there'll be all kinds of other authorities and also other factors that would come into play if there was that sort of application. I mean, quite apart from the fact that this is an arbitration agreement that he's agreed with himself, the claims that the cases where case management stays have been imposed have all been cases where it's the claimant who has parallel claims.
But in either event, whether it's a stay under Article 13 or a case management injunction, they're not premised on the court not having jurisdiction.
Correct. Correct. They're not jurisdiction applications.
No,
they're applications for a stay. So we do say there's no case management stay application on foot. And all I'm saying is this is not just a technical point, because if my learned friend made that application, we want a case management stay because there's an arbitration agreement between D2 and D3 that covers the same ground as these proceedings, then you would want to do an evaluative exercise. And the test in those circumstances for case management stays, which you find in the cases that my learned friend refers to, but also have been adopted in this court, is there a rare and it is a rare and compelling case. Well, there needs to be a rare and compelling case for a case management stay. It can be justified in some circumstances where one party brings two claims which either depend on each other, one of which or are very closely related. But there is no case that my learned friend can show you where a party brings a claim against first defendant and that is somehow blocked in this court because the first defendant has a arbitration agreement that covers similar ground against the second defendant. And that even if there was that case, one would then have to look through to the realities of this case. Is there an arbitration on foot? What are you staying it in favour of? Answer, nobody's even suggested that there's an arbitration on foot. Even if they were to suggest that, who would that arbitration be brought by and who would it be brought against? On the first defendant's case, by himself, against himself, wearing two different hats. He would be sending himself requests for arbitration. Are these the sorts of circumstances where this court would contemplate saying to a party who has been trying for 15 months now to give effect to a valid resolution, to take control of a company, is that the sort of situation where this court would contemplate saying, no, you have to wait some more time, indefinite amount of time, before you are able to vindicate your rights? We say it is just another way that the first defendant is trying to block, trying to prevent, trying to throw up procedural hurdles to prevent us getting inside the company, prevent us getting access, particularly to the books and records of the company, and ultimately to prevent us from finding out what's gone on, because we still don't know. So that's the first answer to the arbitration point. If you need another one, the second answer is also a waiver point. It operates in a slightly different way, because if you've still got Article 13 of the arbitration law, you will see what is required. A request not later than submitting his first statement on the substance of the dispute. And so the question for Your Honour will simply be, when you look at the witness statement, when you look at the skeleton argument that was presented last time, when you look at the oral submissions that were presented last time, was the third defendant making a statement on the substance of the dispute? And if my learned friend says he was not, we find that quite surprising. My learned friend has some other points on this. He says, in Your Honour's procedural order, which came after, that there was a deadline set for an application for jurisdiction disputes, and therefore his client was permitted to make this application at the time that it did. But that says nothing about the outcome of the application. We don't say that the court shouldn't hear this, but it doesn't preclude any of the issues that we can raise in that application. And it doesn't preclude us from saying, well, they've already made their move on the merits. My learned friend, in his written argument, though I don't think he picked it up, he also said, well, there's no prejudice to the claimants because the third defendant has always said there's no jurisdiction in this claim. We don't accept that. The third defendant, as I've shown you, actually tried to file acknowledgement of service, saying it was going to defend the claim. But all of that is irrelevant anyway, because prejudice is not the test. And the other points that my learned friend raised are really about jurisdiction, not about arbitration. So that's it, really. So, Your Honour, we do say that the arbitration arguments are borderline incoherent. They don't get off the ground at all. And it would be very surprising if this court was to say that a claim brought by a non-party could be prevented by the existence of an arbitration agreement, particularly in the circumstance of this case. Your Honour, that is all I was going to say in response on these particular issues, unless there's any questions that you have for me further. Thank you very much.
No, thank you, Mr. Montague-Smith. What we might do is have a reply from Mr. Doherty, and sure you will ensure that it is just a reply, Mr. Doherty, not a repetition.
Yes, Your Honour, ask for a brief 5-minute comfort break before we kick on with the rest, if that's all right.
All right, and you might, whilst you're doing that, think about where we're going for the rest of today.
Certainly. Thank you, Your Honour.
All right, now wait a minute. It's I make it would be 3:58, so we'll come back at 4:05.
Very good, thank you.
Yes, Mr. Doherty.
Thank you, Your Honour. I will be brief. If I can, I'm not going to dwell on this at any length at all, but very briefly in the submissions which were less central to these applications and more about the conduct of the parties, there are just very brief 2 points that need to be made. One, Your Honour would be forgiven for thinking that somehow the first defendant is the great big bad guy in all of this, when in fact there's clearly a legitimate dispute over who's acting in the best interests of the company in this case and who's acting in the second defendant's interests. And you've been taken to all of the evidence before about payments not being made to the second defendant by companies controlled by the claimants. And in fact, the claimant's position in these proceedings now is that, well, actually, those payments aren't even the second defendant's property. The second defendant's just a wallet. It's acting as a recipient of funds for tax purposes only, and the funds are owned by HI Egypt. And really, the short point is that one has to consider that it's the first defendant who's acting in the company's best interests, and that's the reason that it has adopted the position it has in these proceedings. So we don't accept these characterizations of this is all a roadblock. This is a legitimate dispute about who has the right to act in the company's interests. And it's for that reason, and again, I'm going to deal with it very briefly, but we take issue with the characterization of the inter-parties correspondence, which I know Your Honour probably doesn't want to hear much about, but you were taken to a letter, which was in response to a letter from the claimants saying, hand over the privileged advice you've given to Mr. Shehata, or we'll report you to the regulators. So there's always a context which is important behind these communications. I don't think it advances everything today, but I think I need to put on the record that my instructing solicitors take issue with what was put. Moving on to the more substantively important points in this case. And the claimant's position was in effect, well, Your Honour, if we've gone about the procedure in the wrong way, you shouldn't use that to prevent us from asserting jurisdiction, whilst on the other hand saying, well, the third defendant's gone about the procedural matters in this set of proceedings wrong, and so should feel the full force of that, and you shouldn't consider its arguments. We don't accept that, clearly. What my learned friend sought to portray is, I think, the third defendant seeking to adopt some kind of tactical approach in this case, through which it avoided putting in its acknowledgement of service prior to the last hearing. I'm not really sure what the tactical benefit of that would be. I explained the position at the last hearing, which is if you've not been listed as a party, you can't select the party in the drop-down menu, you can't file an acknowledgement of service.
The substantive point, Mr. Doherty, I thought the substantive point is whether in the witness statements filed before that hearing and at that hearing, you made submissions on behalf of the third defendant which went to the substance of the case.
Yes, and the answer to that is that no submissions were made to that effect. And really, there are 3 points to make. It must have been perfectly clear, both to Your Honour, the court, and everybody else, that the third defendant's position was that it did not accept joinder or jurisdiction, because the skeleton argument prepared for the hearing said that. during the hearing itself, we referred to the fact that that was the third defendant's intention, and that was then reflected and recorded in the judgment itself that was issued, I think, on the 15th of May. And to the extent that the point is put, well, the court did resolve the Part 8 part of the claim, so that was the valid resolution. That's nothing to do with the third defendant. It wasn't a claim against the third defendant. It was a question that involved, at best,
I thought
the second defendant.
more pertinent, Mr. Doherty, was the submissions that you made about the, I think I referred to as the set-aside claim. I think it might have been the label I put on it, which went to the substance and merits of the case as being reasons why it should not be determined. And those submissions were made on behalf of all defendants, is the point that's made against you.
Yes, but those are submissions. It can involve a consideration of what the factual issues will be in due course. But fundamentally, the statement that was put in was pursuant to direction from the court saying, please provide evidence in relation to your application that the Part 8 procedure is inappropriate, which is precisely what it did. And in any event, the directions of the court have been followed thereafter in respect of the timing of filing the application. So it's a statement which refers to facts in the context of how they affect the procedure to be adopted by the court. Should it be Part 7 or should it be Part 8? But it wasn't about substantive relief or a substantive position. And there's authority, which I referred to in my skeleton. I didn't take you to it because I don't know how much of this is a genuinely troubling issue, but there's the case of BankMed and Fast Telecom, which refers to Article 13. Again, it's not on the bundle. I'm going to have to provide it in a schedule, but if I can give you the relevant points.
Yes.
It says, firstly, for Article 13, for Article 13 to apply, firstly, the matter brought before this court must be the subject of an arbitration agreement. And secondly, you must request the action to be dismissed or stayed no later than when submitting the first statement on the substance of the dispute. And thirdly, the arbitration agreement must not be null, void, and so on. And in the context of this case, it's talking about a scenario where there was default judgment and an application to set aside. And what is said at paragraph 11 is, I'm satisfied the third defendant did request at the earliest opportunity for the action to be dismissed or stayed, namely in its application for dismissal or stay of the claim under Article 13. It is correct that the third defendant had previously submitted a statement on the substance of the dispute. However, that was after default judgment had been entered against him, and so it was not possible for him to request the action, which had effectively come to an end, be dismissed or stayed. In that statement, the third defendant appropriately sought that the default judgment against him be set aside. I do not think that the draftsman of Article 13 intended to catch out those against whom default judgment was entered, and therefore would not be in a position to request that the action be dismissed or stayed. And it says, with that said, in any case, I regard that, and given the nature of the third defendant's first submission, being again an application for default judgment be set aside, the third defendant sufficiently gestured towards the second requirement of Article 13 when he said in that submission, the third defendant intends to show the DIFC courts do not have jurisdiction over this claim, as it is subject of a valid and binding arbitration agreement. The consequence of a valid and binding arbitration agreement, and so the implication, is that in the action, those courts should be dismissed or stayed. Accordingly, I'm satisfied the third defendant has satisfied the second requirement in Article 13. So the point really is the same. From the earliest point, the third defendant has always notified its intentions. In the skeleton argument for the hearing, which was about the use of Part 7 or Part 8 procedure, it said directions will need to be made as to the filing of an acknowledgement of service and the jurisdictional points that were going to be taken by the third defendant. I mean, on that basis, say there isn't really a credible argument that the third defendant should operate under a procedural bar in this case, not least, as I said, because of the way in which these issues have ended up coming to the court anyway, and the way that Joinder took place. The next point I wanted to address was what was said about Nest. I don't think that there's any dispute between the parties that the jurisdiction in Nest allows the court the power on the application of that test to assume jurisdiction over a party that it would not ordinarily have jurisdiction over. The important point, though, is that it is central to that jurisdiction how the court has gone about joinder. And I know there's a difference between what I say and what Mr. Montague-Smith says about Nest and what the court has to say about the procedural bar. I think the position set out by my learned friend is, well, it's only in the court of first instance in Nest that they refer to this procedural bar, that you have to act in a particular order for the jurisdiction to be enlivened. We don't agree with that. We say that the Court of Appeal it's page 1781, but paragraph 18, the second sentence is commentary on what was said in the court of first instance. The first sentence repeats what Justice Giles said, but the second sentence isn't what appears at paragraph 18 of the first instance decision. So what the court is doing in the second sentence of paragraph 18 is reflecting what was held below, and which was ultimately accepted by the claimants and in any event not under appeal. And the Court of Appeal said that in its own terms, the rule is only applicable to a situation where the new party is to be added to the existing proceedings, and the relevant test set out at paragraph 1 or 2 is met. So the position ultimately comes to a question of how joinder is effected. And for joinder to carry with it jurisdiction, it has to go through the test set out at Rule 20.7. And Part 20 contains a whole host of different ways that a party can be joined to proceedings. I outlined one at the start, which is if you haven't served proceedings, you can just add the party. You don't need the court's permission. And I don't think that anyone is saying that joinder under those circumstances would be sufficient to enliven the court's jurisdiction. It is critical that a discretionary exercise is conducted by the court, and that the rule is intended to convey jurisdiction through the exercise of that power. And that is clear if one looks at the decision in Sandra Holding. At paragraph 54, which I'm just digging out the page reference. I'll get you the reference, but while it loads, I'll run through what the court is saying there. So paragraph 54, it says, there is another clause of Article 5A1, which the respondent relied on, and that's Article 5A1E. The page number I can give you now is page 1826. And the Court of Appeal runs through the Nest jurisdiction on the basis that it's rules, regulations issued by the DIFC. And it sets out what the test is in Rule 20.7, and it does it in contradistinction to another rule that was under consideration, which is 25.24. So 20.7 says the court may order a person, and it's underlined by the Court of Appeal, to be added if, and it sets out the test. And 25.24 says where a party, and it underlines, wishes to apply for an interim remedy, an application must be made in accordance with Part 8. And what the court's saying about this, if you continue down from paragraph 56 onwards, which is the question that arose in Nest, is not whether the rules of court constitute DIFC regulations, and if they do, whether they're intended to confer jurisdictional power as opposed to a limited procedural power. The court concluded and unanimously agreed that Rule 20.7 did indeed confer jurisdiction to the court to add in a new party to proceedings. The wording of 20.7 was deemed to be wide enough to confer jurisdiction and give the court the discretionary power to grant the relevant order if the criteria set out in RTC 20.7 is satisfied. And it refers then to paragraph 39 of the judgment in Nest. And then paragraph 58 says that the RTC can't add or extend the DIFC court's jurisdictional powers without clear expressive words to confer such powers. The ruling in Nest should not be taken as an indicator that the court has conclusively determined that all rules in the RTC confer jurisdiction on the DIFC courts. Instead, one needs to make an assessment on a case-by-case basis to determine their true effects and ascertain if the relevant rule, in fact, confers jurisdiction. And then it sets out what the distinction between Rule 20.7 and 25.24 are, which is the 25.24 provides a general power which the court may exercise when
But
granting
there's no argument about any of this, is there, Mr. Doherty?
Well, I think there is, because I think what my learned friend said was the fact is that an order was made for Joinder, and that's not really the point that we're taking issue with. We know and accept that an order was made, but what is important is how the order was made and what power the court was exercising in making the order. And that Nest, together with what's said about Nest and Sandra Holdings, says that for the court to apply a rule in a way which gives the DIFC court jurisdictional powers, the rule has to have clear and expressive words. And they've said that in Nest, the Rule 20.7 contains sufficiently clear and expressive words. And the simple point is that in this case, Joinder wasn't affected under Rule 20.7. There was no application, there was no consideration of the rule, there was no argument about any of the tests. And so that's the distinction. You can't just say that because Joinder has happened, ergo there is jurisdiction. The critical question is how Joinder happened and how the court went about dealing with that.
Or is not the critical question whether the criteria are satisfied?
Well, again, we say that the answer to that is if you're satisfied that the order for Joinder is made in the way I said, you don't get to that question.
No, you're talking about the procedure. You're talking about the procedure. I put it to you, isn't the question as to whether the court's got jurisdiction, is whether the criteria are satisfied.
No, because otherwise you would have had the position in Nest being that it doesn't matter if the party is joined from the outset of proceedings, because the court could take a view, well, had they been joined subsequently, then the test would have been satisfied. So the situation here, I think, puts you in precisely the same position that was laid out by Justice Giles at first instance in Nest, where because the power has already been exercised before the court considers the exercise of the power under 20.7, it's too late.
But the Court of Appeal found it wasn't too late. The Court of Appeal found that there was jurisdiction.
I think this is where the difference between where our position is and what Mr. Montague-Smith said, which is that the court didn't interfere or criticise or overturn what was said below about the proper ordering of the exercise of the power. And that's why, as I said, Your Honour, I brought you to...
But the court found that it did have jurisdiction, notwithstanding whatever procedure and whatever had happened.
But that's not really the point that we're engaging with here. The question is, if you go about things procedurally in the incorrect way, is it too late to subsequently rely on the effect of 20.7? And the views expressed in the Blue Book are that, as the law stands, you have to serve your claim form and then the application, and otherwise there needs to be a change to the rules or to the court law. And I think that the minor point of difference between us is whether or not the Court of Appeal endorsed that view or not. But we say that that is a procedural bar which applies, and one can't get around, so it will need to be addressed by Your Honour. But in any event, I mean, there are always prejudicial submissions. That there any order that one can take their submissions in. I don't think I shortchanged you in the amount of time I spent talking about the substantive test. I think I've given you quite a lot of detailed submissions on both points. And I didn't think that the order in which I decided to address it says anything about the merits. It's just that one chronologically flows before the other and makes sense to deal with it that way. Just check. Yeah, the final point is in relation to what's said about Article 13, and that the parties are not parties to arbitration agreements. Our primary submission on that is it doesn't matter, the court can still stay. There's nothing in Article 13 which says and that all of the parties to the relevant litigation need to be parties to the arbitration agreement. But I also note within that, there hasn't really been any attempt to address the problem with the newly pleaded case on authority, because I think the answer was given that, well, at least insofar as it concerns the claims which, again, we disagree on this, but which my learned friend says are statutory under the DCC regs, and how that has any relation to the case that's put on authority, which doesn't arise from the Articles of Association. It doesn't arise from any claim under the DCC regulations. And if it is an issue, if there is a genuine question about the authority in the execution of both the assignment agreement and the arbitration agreement contained within it, that can only be an issue between the second and third defendant. That's, I believe, what I had noted down to say in reply. I don't know how Your Honour wants to proceed. I mean, what I can do is...
I'm going to talk to you about now. We've got this second application that you've made. I've got your written submissions. Is it feasible for each of you to deal with it in half an hour each, or something in that order?
Yeah, it's a much less involved series of points than what we've done with previously. I can deal with it in half an hour.
That only takes us down to less than 2.5 hours. I was trying to get it down to know whether something in the order of half an hour is going to be sufficient for each.
I think we can. Well, I would speak for Mr. Montague-Smith, but I think we can probably make that work, particularly where you've got skeletons already. I should add that I don't think that there's going to be any lengthy discussion about directions. I think it's just a matter of dates.
Yeah. All right, Mr. Montague-Smith, do you think half an hour each is going to deal with it?
Possibly. I'm a little. I'm not terribly content to be confined to that, because it's my learned friend's application, and my current timetabling is he's taken 3 hours and 5 minutes. I took 1 hour and 1 3/4 hours.
Yeah.
If the result of that is that I get guillotined on my response to his application, I would have some objection to that,
I think
unfortunately.
what we'll do is that we will proceed on the understanding that this is going to take much less time than the argument we've had so far. I've got your written submissions. I'm not going to guillotine you, Mr. Montague-Smith, but I'm going to go forward on the basis that this is going to be a much shorter application. I also note for the court staff, it's now 4:30, but I ask you to bear with me as we continue on for a little while. So,
Your Honour, sorry to interrupt. There is one other issue. There are some other issues of case management that arise. Now, they're relatively limited in scope.
yes.
But obviously, we're quite concerned about some of them, like, for example, fixing a trial date. Now,
Yes.
some of that can be done offline and all the rest, but you know, my junior, Mr. Jackson, was going to deal with that on our behalf, and I don't know how long that would take, but one could easily see that taking half an hour or so. I don't know how you want to proceed on that, and I mean, one option would just be to do that, and then we'll just you know, have to deal with the set aside application some other time. And given the timings that parties have taken, I would have thought that might be the fairest outcome, but there we are.
Mr. Doherty, is there any urgency about the second application?
But yes, I think there is, because I think things are moving in the local courts as a consequence of the enforcement order. So I think it's not going to be lengthy, I don't think, making the submissions about that. As far as I understand it, the only real issues left for the CMC are agreeing dates, and I think there's only really about 3 weeks between us.
What we'll do, and I think now that I've brought up an email, the way in which originally scheduled we were going to deal with this was the jurisdiction argument, then the CMC, and then the second application. So we might proceed by going through the CMC issues, and then we'll see how we're placed after that. So now, Mr. Montague-Smith, are you going to cede? I see. Yes, I see Mr. Jackson's now.
Your Honour, yes, Mr. Jackson's going to take over just for this bit of it. Thank you.
All right. But what are the issues that we need to deal with on this? Mr. Jackson, perhaps you should go first.
Thank you, Your Honour. There are 3 issues. The parties have agreed the case memorandum and the list of issues. So, as we see it, the CMT issues are limited to, first, any amendments required to the procedural timetable to trial. And there's been some correspondence between the parties on that. Second of all, setting a time estimate for the trial itself. And third of all, fixing a date for the trial, which, as Your Honour may have seen, we flagged in our skeleton. We invite Your Honour to do that at this hearing.
Yes.
If I can deal with the amendments to the procedural timetable first, there was an email sent by my instructing solicitors to the registry this morning, which set out the parties' competing proposals on the timetable. I don't know whether that's reached you.
I'm afraid I haven't seen it. That might be my fault. Let's see.
I should say, in any event, the difference.
I haven't read it, but I'm just bringing it up now.
I'm great. There should be a track changes version of the revised procedural timetable, which sets out in track changes the claimant's amendments to what the defendants proposed.
Just bear with me for a minute. Revised comparison. Let's have a look at that one.
So if Your Honour goes to page 2 of that.
Yes, I have that.
The original deadline column reflects the deadlines that were put in Your Honour's order of the 12th of July.
Yes.
The post-extension deadline box, the unamended text is the defendant's proposal, and the amended text is the claimant's proposal. The difference between us, there's no difference in terms of the time period between each step. The only difference between us is that the defendants seek an extra 21 days for filing and serving the reply to defence to counterclaim. So they're seeking 42 days in total for that pleading. Let
me just see if I follow this, Mr. Jackson. The original deadline was 18 September. And now what I've got is 30 was crossed out and 9 is now inserted. So what does that mean?
So what that means is the 30th of October is what the defendants have proposed.
Oh, I see.
And the 9th of October is what the claimants have proposed.
Oh, I see. Sorry.
So what the defendants are seeking is an extra 21 days. And then there's no dispute to the parties that the rest of the directions follow with 21 days, 7 days here and there.
Yeah.
The reason that's been given by the defendants for seeking an extra 21 days in correspondence is simply that the court granted the claimants an extension of time of 21 days for filing and serving our reply in defence to counterclaim. We say plainly that's not a sufficient reason to extend time for the defendant's reply to defence to counterclaim. There's a stark difference, we say, between the party situations. We made a formal application on notice for an extension. It was supported by evidence. It was made specifically for 2 reasons. First of all, because D1's defence and counterclaim raised a host of new faction legal issues. And secondly, because the deadline would otherwise have fallen during the summer vacation period, and the claimant's legal representatives had availability issues during that period. And it was granted by the court in light of that evidence and specifically for those reasons. There hasn't been any formal application or any application at all by the defendants for an extension of time. There's no evidence setting out the reasons why an extra 21 days is required. And we would say it's not, the court doesn't proceed on the basis that simply because one party gets an extension, there should be an extension afforded to the other party. And that's particularly so where in this case, we're dealing with a pleading which is a reply to defence to counterclaim, which one would hope should be relatively limited in scope. So that's our position on the procedural timetable.
Mr. Doherty?
Yeah, sure. I wonder whether there's just a bit of cutting through this that can be had. The extension that was granted to the claimants is one of a number of extensions that they've got, landed us in the middle of the preparation period for where I would normally be working on the reply, but was in fact working on preparing for this hearing. I've seen the gaps are all equivalent. Really, it's just a question, as it was for the claimants, of availability, counsel availability to the reply. And so what I'm going to suggest is 21 days.
Mr. Doherty, I know it's always very attractive for counsel to say they had time, we should have time. But as Mr. Jackson says, that's not the way it works. The question is what time you reasonably need and why.
Yes, well, what I was going to suggest is that, of course, what we've had in the interim since the deadlines all shift was this hearing, which is, we would say, understandably been the focus of the parties, and so 21 days from today.
But you could all walk and chew gum at the same time. I'm
not sure I've got that level of coordination, Your Honour. But really,
I'm not really a bit puzzled that this application, preparing for this application, would cause a delay of 21 days. I mean, you don't spend 21 days preparing for this application.
I'm sure, as Your Honour appreciates, there are a variety of things that end up in counsel's diaries.
Sure.
I agree with you. We don't need it to be the 30th of October, but
well, that's what I'm trying to get to. What I say, I'm not interested in how long they got, and therefore what you should get. I'm interested in what in reality is required, starting from Mr. Jackson's observation that I assume this is going to be a fairly limited compass. We're talking about a reply to a defence to counterclaim. I wouldn't have thought it's going to take a great deal of time. Now, I'm sure you're busy, and it's not something you can do between now and 8 o'clock tomorrow morning. But what do you reasonably need?
Yeah, sure. My suggestion was going to be that we run it as though the normal timetable for a reply, i.e. 21 days, just runs from today. But perhaps if we just
Mr. Doherty, that seems to be ignoring entirely what I've been saying, that you're just going back to formulas rather than what is actually required.
Well, I'm fine with curtailing that, but what I'm saying is, in terms of timing, allowing other commitments, we probably ask for, I don't think Your Honour's going to give me the 22nd, but the 18th, so it's the close of week after next.
All right, so you're saying the 18th, that's the end of next week, is it? No, that can't. Oh, yes.
No, it's so 2 weeks from today is the 15th, and then it would be the Friday of that week.
So it's the rest of this week plus 2 more whole weeks. Is that what you're asking for?
Yes, I suppose it is. I mean,
is that really? Do you really need that? Well, why don't we make it 2 weeks from today? So that would make it the 15th, wouldn't it? So what we'll do, Mr. Doherty, we'll make it the 15th of October. And if when you, those instructing you have put together all the instructions they need to, and if it turns out you've got a real problem in getting it done by the 15th, then you can send in an application to extend the time, but I think we need to keep it moving. So we'll say
Yes.
the 15th, but if you need more time, you can ask for it.
Yes. Aside from that, I think that's really the issue. The rest of it all just follows from whatever that first fixed point date is. And so I don't know how much more one needs to get into it. You adjust the dates accordingly.
All right. Well, I'll leave you and Mr. Jackson, or those instructing you, to work out the calendar that flows on from that. And does that take us to the questions of length of trial and trial date?
Yes, Your Honour. In terms of the time estimate for trial, we have filed the case management information sheet. I'm not aware that any's been filed from the defendants. I can tell you what our position is in terms of witnesses. We intend to rely on 2 factual witnesses. We also seek the court's permission to adduce expert evidence from a forensic accountant. And what that will address is the profit realised as a result of the purchase order and the assignment agreement. So it's relevant to the account that we seek from the court.
Has there been any orders for expert evidence?
The way it was dealt with in Your Honour's order of the 12th of July was both parties were to include it in their case management information sheet, but I believe the order also referred to seeking permission. So there hasn't been any orders formally permitting expert evidence yet. That has been referred to. But what we would ask Your Honour to do is include, for the avoidance of doubt, include a provision in your order granting both parties permissions.
Yes, I will do that. What time do you need for that?
Well, I do somewhat need Mr. Doherty to confirm which factual witnesses and how many he's going to be relying on.
Well, no, I'm talking about the expert witnesses for the moment.
In terms of how those are addressed in the timetable, so those have been included in the procedural timetable that both parties.
I'm sorry,
Yeah.
where is that?
So they're towards the end of the timetable.
Yeah, I see.
So that's built in.
And you've got, I see, expert reports, supplemental expert reports. Is there any provision there for a conference between the experts?
No, there isn't at the moment. We can insert that.
Yes, please. And Mr. Jackson, what I'm going to do is that when we've finished this, I'm going to ask you or those instructing you to draw up a minute of the new timetable that we've arrived at.
Yes.
And indeed, you'll need to put in an order for permission for expert witnesses, and that there should be a conference of the experts.
Yes, and I'm sure Mr. Doherty and I can come up with a date for that too. So going back to the time estimate for trial, subject to what Mr. Doherty has to say on the number of witnesses from his side, we were proposing 5 to 7 days as a sensible time estimate. We expect.
How did you get to that time?
Well, taking into account the 2 factual witnesses we have on our side, and we would anticipate, although as I say, it's for Mr. Doherty to confirm, anticipate that the only factual witness from the defendant's side is going to be Mr. Shehata. And then one adds in the 2 forensic accounting experts. I think that 5 days is probably the minimum estimate. We would suggest 5 days with 2 days held in reserve.
Yes. All right. Mr. Doherty, how do you see it?
Yes, I mean, I think the window, at least the upper end, is fine. I think we did put in a case management information sheet. It's maybe just not found its way into the bundle. I don't know what the story behind that is, but I think it was suggested in that it would be up to 2 factual witnesses on expert evidence, and admittedly contingent on what the outcome on jurisdiction is. We had flagged the possible requirement for expert evidence on legal issues insofar as the court needs to consider questions about the ownership of MCC rights and the law that would govern that. So, for example, if evidence is needed on Malaysian law, that would be needed. So that is potentially one that would need to be built in. But
why would Malaysian law be relevant to anything?
well, I suppose one, we don't really know yet what the claimant's position on the acquisition of the rights are. So I don't know what they say about who the rights came to be acquired by the second defendant. But the position advanced by the first defendant is that he authored the rights, that rights were certain rights were transferred to the Malaysian entity. That's means that they have in the Malaysian entity a vested license to utilize the economic rights for MCC, and which they can then assign or effectively license other partner resellers to resell licenses for MCC. And if there's a question about does the Malaysian company own...
Mr. Doherty, so I understood it going back what you're talking about. Before you get to the question of licenses, the first question that seemed to be an issue was the ownership of the rights. And why does Malaysian law govern that?
Well, this was going to be about how the relevant rights were held at the date of the assignment agreement. But yes, you're quite right, Your Honour. One could see that there's potentially an issue of the vesting of the ownership rights from authorship in the first place. I think the main point is that, subject to the outcome of the application I've just made, there may well be issues of foreign law. Insofar as there are, I think they could be accommodated within the same timetable.
All right.
So the steps for those experts would be the same. But I think that probably means that there is sense in...
all right, I might just go back to Mr. Jackson for a minute. Mr. Jackson, you told me 2 fact witnesses. Who are they?
They're the 2 claimants, Your Honour.
Right. Now, Mr. Doherty, you're talking about 2 fact witnesses. Who are they?
Yes, it's Mr. Shehata, and the current anticipation is one other, but it's not... I can't confirm precisely who that is at this point in time, but that's...
Well, it might be relevant to how long it's going to take. Can you identify this by some sort of position or what they're going to give evidence about, or can we get some idea whether this is going to be a witness who's going to spend a day in the witness box, or somebody who's going to spend half an hour? Or...
No, so I understand that the bulk of the evidence is going to be from Mr. Shehata. So the further evidence is likely to be on discrete points. So concerning the operation of the Malaysian entity, for example. So in terms of overall timing, it's not one that substantially moves the needle.
All right. Yes. All right. Well, listening to the 2 of you, it seems to me that a 7-day estimate is reasonable. Now, I know Mr. Jackson spoke about 5 days and 2 days in reserve. I must say I'm never quite sure how that works. If you've allocated 7 days, you've allocated 7 days. If you finished in 5, all well and good. So it seems to me it's 7 days.
I'm grateful, Your Honour. Could I just address you on the expert evidence point on Malaysian law?
Yeah.
It doesn't appear to us that would be something which would be reasonably required. The court can obviously deal with foreign law by way of submission, and Malaysia is a common law system. There hasn't been any pleading thus far in these proceedings of any specific provision of Malaysian law which is said to be controversial. So we would invite you not to grant permission at this stage. Of course, if at a later stage it does become relevant and is pleaded, then my learned friend can make an application to vary the permission.
Mr. Doherty, I think that probably seems reasonable, isn't it, that the permission should extend to accounting experts. At the moment, and I think you said the pleadings don't really tell you, or you're not able to form an opinion yet from the pleadings whether you need evidence about foreign law, and if so, what it is. So it might seem
Yes.
premature at this stage.
Yeah, I think that's our expectation. It's more of a flagging that is a potential issue, but saying that if that is to become an issue, then it will just be in accordance with the timetable that's already been provided. It's not additional to. And so I suspect you're right to cross that bridge when we come to it.
All right, but just to be clear, so the orders which Mr. Jackson's instructors are going to prepare will include permission to lead expert evidence from accounting experts, but will not at this stage include permission to lead evidence from experts in foreign, whether Malaysian or other law. That's a matter, as you said, Mr. Doherty, will cross that bridge when we arrive at it. All right.
Thank you.
Yes.
Does that take us to trial dates? Is that the?
Yes, it does. From our side, the directions currently end, I think it will be around April, May next year, with the adjustment to allow for an additional time for the reply to defence counterclaim. I think it's mid-April, actually.
Right.
So that's when the directions would currently end. But we have some availability issues on our side in, I'm afraid to say, April, May, June and July, both on the council side and on the solicitor side, respectively, at different times. August is obviously the summer vacation, so we would invite Your Honour to fix a trial in September next year, provided the court has availability then. And we suggest that if the court can accommodate it in mid-September.
Mr. Doherty?
I'm just looking further ahead. I was preparing to respond, Your Honour, on June, because I've had two CMCs, both of which are trying to list June trial dates. So I was coming on to deal with that. I didn't expect we'd be going to September. I'm just looking further forward. Yeah, I can't foresee that that's going to pose a problem. I imagine what we would do is the parties would suggest to the court a trial window commencing on a particular date in September. If there are any dates to avoid, although it doesn't sound like there are many, we provide those to the court, and then Your Honour looks at whatever your own trial calendar is and selects.
Yes, please. I think there's two things which have to be accommodated. Well, perhaps I'll finish what I was going to say, then come to another point, and that is that a trial of 7 days, practice is that would be held in Dubai, not remotely. That means that as well as my availability, we have to ensure that the courtroom is going to be available. But that takes me to the next point, and that is, are you both proceeding on the assumption that the trial will be in Dubai and that the witnesses will be in Dubai?
From our side, Your Honour, we had put in the case memorandum that, sorry, not in the case memorandum, in our case management information sheet, in respect of our two witnesses, I think we had requested that they be permitted to give evidence via video link, considering where they're based. Simply for the convenience and to save the expense of them having to travel.
Has this been discussed between the parties?
And not as far as I'm aware. As I say, we did flag it in our case management information sheet, simply because they're based in Saudi Arabia and Egypt respectively, and it seemed to us a more economical way of doing it.
Mr. Doherty, what's your view on the matter?
I suspect it's largely a matter for the court's preferences to how it wants to hear from its witnesses. I mean, I've conducted remote trials, I've conducted in-person trials, and I think I've got a hybrid trial coming up. I know that the DIC court can do them all, but it's really a matter of judicial preference, I think. Well, and particularly where it's a 7-day trial.
My preference is this, Mr. Doherty, that the expert witnesses, I think, can adequately give their evidence remotely. I don't difficulty with that. The principal witnesses in this case, I anticipate there's going to be extensive factual dispute. Is that a reasonable anticipation?
Yes.
Yes. Well, given that they are going to be, there's going to be substantial factual dispute, given that the witnesses are either the parties or the principal protagonists, my view is that they should come to the courtroom to give their evidence.
Very good, Your Honour.
All right.
I think that takes us to the end of the CMC issues, unless there's anything.
All right. So, and
Mr.
Mr. Jackson, you will, with your instructors, arrange to send in a minute to give effect to what we've said.
Yes, we'll do that.
All right. Thank you, Mr. Jackson.
Thank you, Your Honour.
All right. Let's go back then. I see Mr. Montague-Smith has reappeared. We are now at 5 p.m. in Dubai. This is well beyond normal sitting times. Mr. Doherty, you want the matter dealt with quickly. I am reluctant to keep sitting. There is, as I say, a limit to how long one just keeps going. What sort of availability do you have in the next, I'm not sure that I'm available for the next 2 weeks, but let me have a look. Well, I'm not available for the next 2 weeks, but I am available on the 24th and 25th.
I'm afraid that week I need to travel to Kazakhstan.
Right.
So I'll be sitting there, unfortunately.
It helps somewhat uncharacteristically from the 23rd essentially through to arbitration week when I'll be in Dubai. I'm also going to be in Australia.
You're going to be in Brisbane, are you?
I'm not actually. Perth and
Perth. Okay.
Yeah.
I thought arbitration week was in Brisbane this year, but.
Oh no, I'll be going back to arbitration week in Dubai, but it does pose some problems with availability. I mean, I'm going to say I think that there are alternative approaches. One is you confine what I have to say orally to say 15 minutes, and I just give you what I've got, and Mr. Montague-Smith can say what he needs to say after that. Two, the parties put in relatively confined, given we've got skeletons already, but any written submissions dealing with additional points or points they would have elaborated on otherwise during the hearing.
Did you say that you will confine yourself to 15 minutes?
Yeah.
All right.
You have main points in writing, so it would be to take you through what the oral submissions are. It might be Mr. Montague-Smith has something to say about that, but.
Well, yes, in light of Mr. Montague-Smith's earlier comments, I don't mean from that he would only have 15 minutes. But I was anticipating if we embarked upon this, that we'd be here for at least another couple of hours, which I'm not willing to do.
Yes, it may help if I was to go off screen for a second and take some instructions, that might help us cut through. Yes. I realise that the more time ticks on, the more problematic it becomes, but I think that's probably the most straightforward way of dealing with it.
Yes, you can.
Thank you.
That.
for the time, Your Honour. I think the preference is, if we can't proceed today, to proceed with it in another date. I suspect that the parties are just going to have to provide their availability in the normal way and try and work out when that is.
Yes, all right. Well, I think that's what we'll have to do. We'll adjourn the application today, and as you say, if each of you or your instructors liaise with the registry about dates, and we'll see what we can do. All right.
Thank you.
Well, I thank you both for your assistance and those instructing you, and I thank the court staff for their patience and perseverance at this hour. Thank you. That concludes today's hearing.
Thank you, Your Honour. Thanks also from us to the court staff too.
Yes.
Thank you.